Sir had an equally rewarding second career in the corporate world, where he rose to become CEO of Apollo Group of Hospitals, Karnataka region. We hope to benefit greatly from your experience during this seminar proceeding, sir. It is also my pleasure to welcome Dr. Vatsala Swami, Director Academics at DY Patil Medical College, Pune, who has been my teacher during my undergraduate days in AFMC. Welcome, ma'am. She is here with faculty and students from DY Patil. A very warm welcome to several senior hospital administrators, faculty, and students who have joined us in person and online from AFMC, MUHS, Jupiter Hospital, Symbiosis Institute of Medical Sciences, Sancheti Healthcare Academy, Bharati Hospital, Pune Hospital, and even medical institutes from Delhi and Dehradun. Welcome to all of you. We hope that today's proceedings will be a value addition to your current and future job performances. What about the topic? Legal and ethical issues have come to the forefront in healthcare because all the commitment and dedication of clinicians is placed under a question mark if legal and ethical guidelines are not followed in a healthcare institution. As Jupiter Hospital logo says, patient first. So if patient is our priority, then following the laws relating to healthcare, which protect the patients and increase their satisfaction with the care delivery, has to be the highest priority for any hospital administrator. I think we all understand that there is a need to follow laws related to hospital building, fire safety, biomedical waste, radiation protection, etc. But it is also important to understand that when legal and ethical issues are respected in clinical areas, then it works as the best safeguard against growing litigation and violent behavior by patients and relatives. Ethics are not formulated by governments. They are formulated by professional bodies, and they are there to guide us when laws are either not yet written or there is a conflict of interest or opinion about interpretation of a law. For example, when we say primum non nocere, which means first of all, do no harm, that's not a law. That is an ethical guideline. That is an oath that we take as healthcare professionals. Therefore, we have for you a glittering array of highly qualified and experienced clinicians, hospital administrators, lawyers, academicians, and leaders from both healthcare and pharmaceutical industry to discuss topics which were selected after a lot of brainstorming. I sincerely hope that you will enjoy the deliberations that follow. Once again, welcome to one and all. Thank you.
It is an auspicious tradition to light a lamp before the starting of an event to invite the gods to us to dispel the darkness from within the hearts of the devotees. For this, I invite Lieutenant General N.K. Parmar, Colonel Surika Kashyap, Dr. Rajendra Patankar, and Dr. Chandramani to come up in front and light the lamp to initiate us on a brighter path of knowledge. We now begin with the first talk of the day, Legal Boundaries of Patient Management, an overview of the Indian scenario by Dr. Santosh Kakre. Dr. Santosh is an MBBS with an MS in Surgery, Diploma Orthopedics, Fellow of International College of Surgeons, a degree in Bachelor's, Master's, and PhD in Law, Diploma in Arbitration and Alternative Dispute Resolution, an MBA in Hospital Management and Finance, an International Fellow of American College of Legal Medicine. He's a general, trauma, and orthopedic surgeon with more than 25 years of practical experience in patient care and surgery with a strong interest in all aspects of medical legal research. Top management positions at several corporate hospitals in Pune, Bangalore, and Nagpur. Currently functioning as a non-judicial member of the State Consumer Disputes Redressal Commission, Mumbai. Over to you, sir.
Third one. Slide. Slides. So, good morning to all of you on this pleasant day with so much bright audience and the faculty who are sitting here, the dignitaries who are sitting here. It's definitely an honor and pleasure in interacting with all of you on this particular important subject. So let me at the outset thank Colonel Dr. Surekha Kashyap for inviting me here to have this interaction with all of you. Basically, I see that the budding hospital administrators are there and even doctors and clinicians, they are present right now. I'm very much delighted to meet the senior most, I will not say hospital administrator, but the senior most and doyen in this particular field, Lieutenant General N.K. Parmar sir. I met him 5 years ago, and then I met him in Delhi in one of the conferences, and after that I followed him and I even met him in his house. And I'm very much happy to meet you, sir. Let me at the outset congratulate Colonel Dr. Surekha Kashyap. And of course, the institute which has come forward is Jupiter Hospital at Baner, and its CEO, Dr. Rajendra Patankar, for organizing this particular seminar. And it's a national level seminar in which I'm sure you will be able to understand the intricacies of the relationship between the doctors and the patients on one side and the overall management of the patients on the other side. So this particular topic, though I will be able to speak till evening on this topic, I'm going to speak for some time. And then the basic important aspect is what are the boundaries? Boundaries are given by the judgments as well. So few of the landmark judgments in this particular field I'm going to discuss, and of course, I'm just going to touch them. Being general and orthopedic surgeon, both. So I did general surgery as well as orthopedics. I was interested in practicing in both the fields for almost more than 20 years, then working in various setups from rural area to the urban area like Pune, Bangalore, as well as Nagpur, as a hospital administrator, medical director, and a CEO. My interest went on shifting to the field of law. And during my practice, I completed LLB, then LLM, then PhD in law, and now pursuing the LLD at Maharashtra National Law University, of course, of Aurangabad. Of course, the field of research is same, that is law governing medical negligence. I'm going to restrict myself and focus on only one point, one issue, that is in the patient management, it is the relationship between the doctor and a patient, which is quite important. And during treatment, what are the legal obligations which are casted upon a physician, that is a clinician, who the treating doctor? So I'm going to focus only on this. So my plan is to take a review or to review this particular situation, today's scenario. And then after the judgments are touched upon, I would invite your questions. And I'm sure you being the students of hospital administration will definitely ask, everybody will ask at least one question. At present, I'm the non-judicial member of the State Consumer Commission. There is a system which exists under Consumer Protection Act 1986. Now it is Consumer Protection Act 2019. The act has totally changed. And this system is three-tier system. At a district level, district commission. Now it is known as a commission. At the state level, it is the state commission. And at the national level, it is apex court, we can say. It's a consumer court. So state commission is the high court of a consumer system, in short. So we are getting the appeals from district commissions. So to tell you in short, the position is equivalent to a high court judge, that is a high court of a consumer system. And that's why the role totally changed to a judge who is sitting on this side and hearing the arguments and the submissions of the advocates, and then giving decisions and passing judgments and the orders. So this is the role for last 5 years I'm having, and that's why I'm in Mumbai. Let us come to our topic. We were about to start at 9:10, and so I think I have already utilized that time. But then I will stick to certain important aspects. Now, what is the meaning of boundary, and does the boundary exist in the relationship between doctors and the patients while managing the patients? So in short, boundary may be defined as the age of appropriate professional behavior. Professional behavior, transgression of which involves the therapist stepping out of the clinical role or breaching the clinical role. So this is what is the definition. So just going ahead, legal boundaries are more important than the clinical boundaries. So this is quite important statement. The reason being, the clinical outcome, though it is important for the patient treatment, it is the legal outcome is also important. The present scenario in India has totally changed, and there is a evolving, or there is a growth of this particular medical law field or legal medicine field as such. Patient management involves clinical as well as non-clinical sub-parts. The professional boundary of the clinical treatment involves clinical boundary, ethical boundary, legal boundary, and social boundary. So the boundary can be subdivided in such a manner. What is present scenario? Way back in 1995, when the Consumer Protection Act was applied to the medical profession, in 1995, The act was enacted in 1986. The Supreme Court in IMA versus VP Shanta said that the medical profession and the doctors do come under purview of the Consumer Protection Act. And that's the reason the patients are consumers and the doctors are service providers. Now, what happened after 1995? From 1995, there has been constantly growth in filing cases, complaints against doctors in various courts, consumer courts. That is at district level, at state commission level, as well as national level. What is the amount of growth? That is 450% growth is there. Now, previously, various other acts used to take care of this particular relationship between the doctors and patients. Like the relationship used to be under tort law, under criminal, right now also under criminal law. I'm going to make reference to that also. Then under constitutional law, Fatal Accidents Act was the oldest act which used to be applied for this particular relationship. And the newest approach is Consumer Protection Act 1986, which was applied to the medical profession in 1995. And now the act has totally changed. 2019 act has come. There was quite hue and cry amongst the medical professionals that whether now the new act is also applicable to the medical profession. The Supreme Court has recently given answer to it, and it has stopped all the discussions that the medical profession definitely is under Consumer Protection Act of 2019 as well. So that's the reason it continues, and we as doctors and the medical professionals, hospital administrators need to take care of these boundaries, that these boundaries should not be infringed by all of us. So the regulation can be ethical as well as legal. I'm not going to go into the details of ethical regulation because it gives the social regulation as well as it is a personal, private regulation, we can say, in person. And the application of Code of Medical Ethics 2002. Of course, now there are changes. This field is also evolving, and with National Medical Commission coming out with further guidelines, and these guidelines are being applicable to the medical profession, this field is evolving. Legal regulation, which we are talking about, comes from various acts which have been passed, legal provisions under the acts, and the landmark judgments. Now, the act is passed by the parliament, but it is interpreted. Various legal provisions are interpreted by the courts, and final say is of the Honorable Supreme Court. There is a one legal doctrine of stare decisis, which says that whenever the superior most court passes any order and sets out the principles, these principles are applicable to all the courts all over India. So this is a doctrine of stare decisis. Now, how is the today's scenario? There are rapid developments and advances in the medical field, and we are now witnessing that the previous practices of general practitioners, family physicians, now totally converted into specialty hospitals, and even now the super specialty hospitals, they have come down. Now, whether this is a welcome change? Definitely, yes, it is a welcome change, because now the advances are being available to the patients at large. And that's the reason the super specialty hospitals like this hospital, at one go itself, the patient receives the final most and the correct treatment. So this is definitely a welcome change. But then it has certain other aspects as well, that the cost of the treatment and the effects of corporatization, the patients are facing that as well. Coming to the health insurance, there is a less penetration of the health insurance, and that's the reason, because of the treatment expenditure, Indians are going below the poverty line, and every year this percentage changes. I remember when I went to Cleveland Clinic to undergo one hospital administration program, I remember that 20 million Indians, they go below poverty line, was my, I can say, I actually submitted that 20 million Indians, they go below poverty line. Today, this has crossed, say, 80 million or 90 million. So that means due course of time, this is increasing, and this uh, difference in the distance between those who can afford and those who cannot afford is also increasing. And the basic reason is less penetration of the health insurance as such. And obviously, for every reason, we have reason to blame the government. So the government is not supporting. Rather, we all are knowing that the healthcare expenditure by the government is about only 1.2% of the GDP. So with this particular information, now let us discuss about the doctor-patient relationship. Of course, in brief, the doctor-patient relationship, it is said that there are various models. I'm not going to go to the academics of this particular thing, but then paternalistic model means I am a doctor and whatever I say is correct and you need to follow. So that kind of attitude is not acceptable by anybody now. So barring this model, all other models are acceptable, and the doctor-patient relationship, though it is now reduced to consumer and service provider relationship, it needs to be taken care of. So if these boundaries, if they are breached, legal boundary means for every aspect of patient treatment, there is legal boundary. That means you did not cross, or you must not cross certain boundary. If you cross that boundary, these are the effects. What are those effects? The patient who is aggrieved can file consumer complaint against the doctor in a hospital in consumer courts. The criminal complaint is usually initiated by the state, but even private criminal complaints are possible. Many a times when there is a table death, operation table death, the criminal law sets in and the process is initiated. Complaint before medical council is another way where the registration of the medical professional may be cancelled, but the medical councils do not have authority or power to award compensation to the aggrieved patient. That the consumer court has that particular power and authority. Complaint before Human Rights Commission, going to the media. This is now easiest way, that whenever some patient or the relatives, of course, they are backed by the politicians and gundas. This is a fact of life today. Approaching media is the first and foremost thing that happens. And that's the reason Dr. Patankar, he is well aware that the image of the hospital in the social media needs to be taken care of. And this is quite important. Violence against hospitals, this also is a worrisome thing. And I'm going to make some reference at the later. And then various illegal ways are there, which we are not here to discuss that. So overall, there is a change in the doctor-patient relationship. Commercialization and consumerism. These are the two most important developments in recent times. Because of the cases being filed against the doctors in the hospitals, now there is an increase in the practice of defensive medicine. It is either positive or negative. Meaning is the doctors are restricting their practice to restricting the number of patients, restricting the timing of seeing the patients, and such kind of defensive medicine or positive defensive medicine in a way by advising number of investigations, referring to the other specialists and the super specialists. So that has also increased. And India has a typical situation by which this particular field has now witnessing the current scenario. The patient has rights. Now, according to the legal provisions, wherever there is right, there is a remedy. Meaning is, whenever the right of any individual or person is infringed, the person can approach court of law for the getting the right, we can say getting his right. Now, what are the rights of patients? Knowledge of facts. The patient must know what is happening. What is happening in the hospital, what is the diagnosis and what is further plan. Number two, while examining patient, there must be due regard for modesty, especially whenever a female patient is to be examined, there is a need that any female attendant must be available. Then the patient must know the knowledge of doctor's qualifications, that the doctor cannot say, yes, I am a specialist and I will treat you. Though the patient must know the qualifications of the doctor. Complete confidentiality must be there. Second opinion, the patient has a right to take second opinion. Rather, if the patient says that I wish to take second opinion, he must be encouraged. Knowledge of the operation, knowledge of discharge. That means while discharging, further post-operative or post-discharge instruction must be given. Now, here comes the question that whether now practicing in the field of medicine has remained safe and whether now we should practice. This has happened. So how one can practice positively with a positive view? But then before that, we will just take a review of what is the meaning of medical negligence as such and how law looks at it. So these are certain examples, and I'm sure you must have seen this particular figure or this picture must have been seen. Retained objects in the body. What can be the negligence? Paralysis because of the splints. Orthopedic surgeon, if anybody is present here, no, they can know this. Operating upon wrong patient. There was a very nice film. Actually, I avoided that bringing that 3 minutes clip. That when it was 1970 film, The Hospital. The surgeon operates upon a patient, and then the anesthetist tells that this is not a patient on whom you were supposed to operate. So such a thing also can happen. Operating upon a wrong side, giving tight plaster casts, anesthetic mishaps, transfusion mistakes, removal of wrong organs, wrong digits, failure to take x-rays. That means multiple fractures are there. But then if one fracture is missed, this may be labeled as a negligence. And surgical errors of ligating different ducts. So what is medical negligence? The law has casted upon a duty on the medical professional. So this concept of legal duty has come from one of the judgments. I'm going to make a passing reference afterwards. And if there is a breach of this duty, in consequence of that, there is a damage to the patient. See, the law looks at it as even if there is a breach of duty, if there is a damage to the patient, then and only then the negligence can be held and the consumer courts award compensation, because the power and authority of the consumer courts is to award compensation. So rather than looking into the serious condition, when doctor is involved in something else, this is a cartoon which is available. Now coming to the total scenario, how it has evolved. I analyzed 350 judgments of Honorable Supreme Court as well as the National Consumer Commission during my PhD in the law governing medical negligence. And there are 10 changing trends which have been seen over the years. So the first and foremost thing is position of medical professional. Whenever medical professional used to be looked upon as a god, now he is not god, he is a service provider. What is the position of the patient? Patient is a consumer. Then the basic principle I'm going to discuss in the later slides, how doctor is labeled as a negligence. See, when I practice as a surgeon, I always used to wonder that when the advocates don't have medical knowledge, when the judges who are sitting on this side, they don't know ABC of medicine, how they are deciding that a particular doctor is negligent. Due course of time, I came to understand that there are certain legal principles and the legal provisions, settled principles are there on the basis of which a doctor is labeled negligent. Then we all are aware that in all courts of law or in all courts, there is a time which they are time consuming and the judgment and orders are delivered at after a lot of pendency. Overall perception is that if you ask a common person, he hesitates to visit big hospitals. The reason is, even if the outcome is good, even if the surveys are good and your presence on the social media is good, the overall thinking of a common man is that the doctors are negligent and they are not having faith or complete confidence in reaching any of the hospitals. So deficiency in service is now taken as the medical negligence as well. Now I'm going to talk about these two principles at a further later point of time. So as I was talking about, there are settled principles and landmark judgments which are giving the basis for defining the liability. Now, criminal liability. Take an example in a hospital like this. When the patient is taken on the table, a young patient is there, after giving anesthesia, suddenly the heart stops and there is a death on operation table. So in such case, the relatives file criminal complaint in the police station. That complaint is filed in the police station, and then further process starts. Now, how doctors can be criminally held liable is a question. Whenever I'm practicing as a surgeon, I fail to understand that how can I be criminally liable? But then the law has evolved like this, and the journey from fixing a criminal liability as mens rea. See, there is one particular principle which is known as a mens rea, that is a guilty mind. If the wrongdoer or offender has guilty mind, which is proved by law, then it is taken that it is a criminal liability of that particular person. But in medical profession, now over the period of time, it is the foreseeability. Means when a surgeon operates a patient, if suppose he is aware that because of his operation, these are the likely consequences and the patient may die as well. In spite of that, in the interest of the patient, if he operates and if he seeks consent, this is quite important. Now, the documentation I'm going to talk about, that the informed consent is the most important consent. Informed consent means the consent which is taken after explaining everything to the patient, that what is the outcome and what are the options available for this particular kind of a disease. So informed consent is an answer. We are talking about the foreseeability. Now, the foreseeability is the concept and the principle which is now taken as criminal responsibility and liability can be fastened if it is foreseeable. It could have been avoided, then the criminal liability is fastened. Now, what are the changes which have taken place? So, basis of liability, bolom bolitho, these are just, I'm going to explain, I'm going to talk on landmark judgments later on. What are the changes that have taken place? Now, the Bolam principle which was the basis of liability, has been now replaced by Bolitho. What are the details of it? One patient, psychiatric patient, 65 years old, he was receiving electroconvulsive therapy. And while receiving electroconvulsive therapy, suddenly, because the muscle relaxants or the anesthesia was not used, he suffered from a fracture, because when the electrodes were kept on the temporal region, with a sudden jerk, there was a fracture. And this created a liability of the doctor. The case which was filed against the hospital, Justice McNair was the person who actually in 1957 decided that whenever doctor follows the accepted principles of a practice, which are actually followed by the doctors or the doctors of the same profession, then the doctor is not negligent. So 1957, of course, this is from UK. This is boon to doctors in hospital, which has proved later on. But then in 1997, of course, 40 years afterwards, Bolitho was a child, 2 years old child. He was admitted for croup, there is kind of cough, and the on-duty lady pediatrician attended this baby in the night for 2 times, finding that the baby is all right. 3rd time she failed to attend that particular boy. And then The boy suffered from severe breathlessness and then later on went into vegetative state. The case filed against the hospital, Justice Lord Brownie Wilkinson, he came to the conclusion after examining the experts from both the sides. Usually what happens when the expert opinion is available in the court of law, the expert opinion on the side of doctors and expert opinion on the side of the patients. So in this case, the Lord Brownie Wilkinson said that whenever there are two opposing opinions of the doctors, then it becomes difficult to decide because the judge is non-medical person. So he put forth a principle of logical analysis. So any expert opinion which is logically correct will be accepted by the judge. In short, the judge has discretion to select the expert opinion which is given. Now, this principle has replaced. So now what happens in the court, when the complaint is filed, the defendant doctor files his say, then the evidence is filed. Evidence means evidence supporting every side. And in that evidence, expert opinion is filed. The whether and how to accept this depends on the judge. So this is again, I can say, a thing to worry. Medical professional, as I said, is not God. Patient is a consumer. Deficiency in service is also labeled as medical negligence. Expert opinion, as I have already told, that there is a sea change in the these particular cases. As such, it is based on the logical analysis. Now, whenever a compensation is awarded by the courts, previously or even now as well, multiplier method of which is used in Motor Vehicle Accidents Act is used, where the age of the person died is taken into consideration, what he might have earned in his life, and then on the basis of that calculated and the compensation is awarded. But now the approach has changed after Kunal Saha's case, that the court also can award heavy compensation by considering punitive approach. So the patient or the complainant can definitely ask for more compensation as a punishment to the wrongdoer, that is doctor. Now, whether really consumer is protected. Now here comes a small interactive session. There's a question to all who are sitting in the audience: which is the only protective tool the medical professional can use in the court of law or in any other authority, against any other authority? So which is the only protective tool which can protect a doctor or a hospital? Huh? Huh. Perfect. So at the first itself, the answer is correct. So documentation is the only thing. If you are perfect and you are, as you rightly said, you certify at the same time, who is preparing the document? Because this is quite important. The hospital administrator has the role to check every documentation must be an authentic and legal one. Another question: what can be the only one action if a medical professional takes? Probably it will reduce the number of medico-legal disputes. Any answer? I think let us ask somebody who is sitting at the back. I think I'm audible to all of you at the back. What action a medical professional should take to reduce the medico-legal disputes? Yes, anybody? Informed consent. Yes, sir. Informed consent. Yes. No. Madam? Two more chances. There is only one answer. Yes. So see the answer. Yes. Counseling of the patient. Yes. So there are a number of things which can be done, but the answer to this question is something different. The answer is, when a doctor criticizes another doctor's treatment, it is known as a medical jousting, which leads to the litigation and further dispute. So every doctor or everybody who is working in the healthcare must avoid to criticize and always respond rather than reacting. So rather than reacting to any kind of a legal provision, any kind of a judgment or the order has been passed by any superior court, rather than that, it's always better to modify our own practice. So practicing with the medico-legal risk management is quite important. Now, what can be the risk management? Good communication with the patient. As already I have said that to have good doctor-patient relationship, good communication is far more important. But it may not guarantee you, because even after 40 years of relationships, the aggrieved patients have approached the courts against the same doctors. Documentation, out of which informed consent is far more important. Good professional indemnity insurance. Personal professional indemnity insurance, at least of a cover of 1 crore. And hospital errors and omission policy must be obtained by all the hospitals. There are 2 different indemnity insurances. So hospital must have. And there is a method of calculating that. So details I'm not going to discuss with all of you. Then third one is, or the fourth one, behavioral training to the hospital staff is key actually. And the behavior of the hospital staff must be very, very, very polite and good. So in no case, the employee must lose the temper, and because a single word uttered by an angry tone will lead to the further consequences and dispute. Be a part of a system that responds in the legal way. So it is the legal way which is more important. There might be thousands illegal ways, but legal way is far more important. And always be prepared. Medico-legally, one must update. And last one is quite important, as I have said. Now, whenever a doctor or whenever a medical negligence matter is there, now I'm just sharing with you my experience when I'm sitting here as a judge. When I open a file, I see that either the case records, medical treatment records are not there, or else if at all medical treatment record is there, it is incomplete. Consents inadequate, and then it becomes very difficult. It's very difficult to save a doctor. There are defenses available. So this is a list of defenses which a doctor can take in the court of law. That this is accepted practice. Whatever I did or I treated is accepted practice. Circumstances led to deciding this kind of a treatment that a doctor can say. Third, there was a contributory negligence by a patient. So though I have told so many things to the patient has not followed. That is contributory negligence. I delegated this responsibility to somebody else, XYZ, and that's the reason I'm not responsible. That's what a doctor can say. Discretion. The doctor can definitely say, I have a 40 years of experience, so I can definitely decide that this is the way. Sometimes this may be accepted. It was an emergency. Of course, if it is proved, this defense is definitely accepted. Error of judgment. Previously, it used to be accepted that yes, it was error of judgment. That's the reason why the patient suffered. But now it is not being accepted. I'm just giving you a caution. My experience, we already seen known complications. So this surgery was having this kind of a complication. There is a list of complications after this surgery that can happen. And so this is from one of the complication list. And so I'm not negligent. Doctor can say definitely. But and next is mishap or mistake. So these are 11 defenses which a doctor can take in the court of law. But for each and every defense, the court asks questions that whether you anticipated this. This is the first question. Number 2, if you have anticipated, what precaution you have taken. Number 2. Number 3, if you have taken the precaution, what is the evidence? What is the document that is supporting? And there usually, of course, it is not that the advocates who are appearing on behalf of the patients, they are foolproof and all, but still the doctors have more responsibility to defend themselves. We have spoken about Consumer Protection Act. Now this is the menace we can say we are facing. The no hospital or no doctor. It's in a survey, it is known by, which was done by IMA, that around 75% of the doctors, they have faced or they are facing the violence either in their lifetime as such. They have faced at least once or twice. Now the time has come probably. These are the very nice cartoons. That along with the history taking, the history of assaulting a doctor, that also one important question which may be asked to a patient and recorded. While taking rounds, you have seen some of the videos, the patient himself gets up and tries to hit the doctor. So now this kind of a dress which a doctor might have to use. So this particular medical legal partnership is a very new concept which is now being followed in US, yet to arrive in India. But I'm sure this will definitely be useful in taking care of the doctor-patient relationship. I can talk till evening on this particular concept, but then we have a limitation of the time. Now, are you frightened to practice as a medical professional? This is, of course, addressed to the doctors. There is definitely such a situation and scenario that the doctors are frightened now, and they are either following the defensive practice or they're quitting. And of course, I have not joined this particular field because I wanted to quit this profession, but then this is an opportunity for me to come on this side, which rarely a doctor has got. The answer is no, one must not. It's a noble profession. One has to follow it. One has to respect all the legal boundaries and then practice in a noble way. A successful medical practitioner is successful clinically, successful financially. Yes, it's also important. Not facing any court matter. In the definition of success, this is a third and important. And the reason for the whatever he faces is most of the times ego, which is developed in the medical profession. One example is there. Just whenever a famous orthopedic surgeon from Mumbai, he came to know that a police inspector has filed a case against him because he treated his spine in a bad way. That's what in a layman's term. And that's the reason he filed a case or a complaint. After knowing that this spine surgeon, who is a senior most in Mumbai, he immediately decided to go to his home and visit. He visited him and said, sorry if I have actually giving any pain to you. So that was the point of time when all grievances melted. See, this is the way, this is an example which one can follow. It may not be possible for everybody to come down to that particular level and follow that. But this is an example. Right. So we tried in Pune, of course, some years ago to develop a model of a monitoring team of doctors supported by advocate team, supported by the team of retired police officials that we last 3-4 years we tried actually, and the units were developed in almost at 10 places. Of course, that is the way, and I am sure you are now aware that even Honorable Supreme Court has recently said that providing security is not responsible to the government, but it is the hospitals who have to take care of their own security. So in that, there are certain models which are available, and these are the models probably might be helpful to all the medical professions as such. How much time actually? We have already crossed the limit.
Yes.
Right. So I think some other time I will definitely would like to speak on landmark judgments, because this gives a boundary. One of the, if you give me 5 minutes, just 5 minutes, I'll just take a review of this particular. Anybody can help me? The landmark judgments, second number. Yes. So the time starts now, 5 minutes for this particular presentation. Why the judgments are landmark? The reason is that they give principles which are to be followed throughout in protecting these boundaries. Settled principles, as I have already discussed, these two, Bolam principle, Bolito principle, both are coming from UK. I'm not going to spend more time. Now, the first and foremost was the Indian Medical Association versus VP Shanta. We know that in 1995, the profession came under the Consumer Protection Act. Without going into much details, the another judgment is Lakshman Balkrishna Joshi versus Dr. Triambak Bapu Godbole, 1968. This has a defined concept of medical duty. While treating fracture shaft femur of a son of a doctor, the orthopedic surgeon from Pune, he applied a pressure while giving Thomas splint to him without or with giving inadequate, I think Fortwin Finargan was used, and there was a sudden cardiac arrest. The boy died. The Supreme Court said, whenever the patient approaches you, you have a legal duty, and that is applicable throughout the India. Then two judgments, Paramananda Katara versus Union of India and Paschim Banga Khet Mazdoor Samiti versus State of West Bengal. The emergency care was not available to emergency patient, and that's the reason the Supreme Court said all the government hospitals must provide emergency care, as well as it is also applicable to the private hospitals with the recent government GRs and all. It says that you have to, whenever a serious patient comes to you, you have to stabilize the patient. If you don't have facility, you have to transport the patient to some other place or hospital where the facility is available. So that's a legal duty upon which is casted upon you. Spring Meadows Hospital and Harjot Ahluwalia, here unqualified nurse gave an injection which was actually patient was suffering from typhoid, high dose of chloroquine was given, and patient suffered from the vegetative state. Here, the father and mother of that particular boy, they are consumers. The court said, Supreme Court said, and a highest compensation of 28 lakh was awarded. Vinita Ashok versus Lakshmi Hospital. Now here, it was the first case where the expert opinion was actually not accepted. And it was a case of a cervical pregnancy which bled a lot. There was a operation which was done, was removal of uterus. Jacob Matthew, everybody must know because these are the two judgments. Jacob Matthews versus State of Punjab, and second one is a Martin D'Souza versus, okay, I'll come to that. So these two judgments, every hospital administrator must have, because the Supreme Court has given guidelines how doctors and hospitals should be treated whenever there is some criminal liability or police complaint is filed. And the Supreme Court said that every now and then doctor must not be harassed, and police are warned by the Supreme Court that the action will be taken against them if they now this is another Samira Kohli versus Prabha Manchanda. This judgment also everybody must have, because it gives the details of how informed consent should be there. Now the days are here where simple general consent is not acceptable. So one has to have informed consent only. What are the elements of informed consent? Number one, the consent must be obtained by a treating doctor. This is very important. He must sign on that particular consent. Number two, who should sign? Patient, relatives, or anybody else, or a friend? Only patient should sign, nobody else. If the patient is unconscious or of unsound mind, then and only then legal representative can sign. Then two witnesses should be there. Before that, all details of the treatment must be explained to the patient. Now, there are certain other discussions that how much detail should be told to the patient. Whether patient, you can explain the patient, yes, in this operation, you may also die. So whether that also should be told. The law says in India, it's somewhat flexible. It says that the complications which are having less than 10% of occurrence may not be told. So this is, but it depends on, let me tell you, depends on the person who is sitting on this side. So it it always depends on the judge who decides this particular. So this again we have to. Martin D'Souza I have already told. Kunal Saha. Now this is a last case which I will talk about. A non-resident Indian doctor, wife suffered from skin problem, treated by steroids. Finally, she died in a hospital, Breach Candy Hospital, initially treated by AMRI Kolkata. The husband, that is Dr. Kunal Saha, could convince the court, that is Supreme Court, that it was gross negligence. It was a negligence, and Supreme Court awarded 6 crores plus interest 6 crores, that is 12 crores was awarded. This was the highest compensation. And after this particular case, the amount of awarding compensation now is going on. Now, without going much into further details, let me thank all of you and the organizers for giving me more time. Let me thank Colonel Dr. Surekha and yes, yeah, and the audience as well. Since it was a job for opening batsman, I think they were focused. I'm sure all of you will definitely remain focused till end, and you will take very good, we can say, principles in your mind which are to be implemented throughout your career as hospital administrator. So let me thank all of you. With the paucity of time, I think we can discuss that during a tea break or something. So let us seek permission of Colonel Kashyap.
We should not dampen the enthusiasm in the morning.
This is on behalf of all private hospitals, where when we appoint a consultant in a new role, we ask for an indemnity bond from them.
Yes.
As I heard you say, 1 crore is what you look at.
Yes, at
I
least.
would really like to know, how do we decide what specialty, what experience, and what indemnity should we collect?
Yes, it's a good question. See, it depends on the possibility of filing litigations against that particular specialty. So it is always backed by these statistics. So who are the ones who are commonly sued in the court of law? Anesthetists, number 1. Plastic surgeons, number 2. Number 3, even the critical care specialists. Orthopedic surgeons, because the outcome is visible. So they are the ones also are. So there is a percentage as such. So roughly, the anesthetists and the plastic surgeons should have maximum cover. So that may be, say, more than 2 crores as such. And the rest of them, since the award of compensation is gradually increasing, it's always better to have 1 crore cover. Of course, there are certain further details which can be discussed in the professional indemnity. It should be 1:1 ratio. So of course, discussing that will consume more time. So I'm just telling you that it should be 1:1 ratio, and more than 1 crore is the minimum requirement, I think. Now the companies, insurance companies, the insurance companies, if it is possible to negotiate with them, then the out-of-court settlement also must be covered, because this is quite important. So rather than fighting a case in the court of law, see, I am now let me share with you that after 17 years, a matter came before me, and I found that it was an advocate who actually filed a complaint against a doctor. I found that this was frivolous complaint. So for 17 years, that doctor suffered throughout. A case or even a notice or even a call from a police station worries or increases the heartbeat of a doctor. So 17 years are quite long time. So that can definitely happen. So sometimes it is wise to settle the cases. Let me just tell you, because the pendency is so high, rather than you can buy peace, also giving justice to the patient. Now this one more concept is there in the New Zealand. I find it very good, that is no fault liability concept. For any damage to the patient may not be because of negligence of a doctor, the patient should receive compensation, because patient suffers, because it is 100% suffering of the patient. even though it is not your mistake. The insurance-based mechanism can be available, and that can be the best system. That's what I think. Yeah. So thank you very much. Please.
I request Sarika Kashyap to kindly present a memento to sir for delivering such a wonderful talk.
Thank you.
Thank you.
Go ahead. There's no need of it out there.
Just take a second more.
All good
That's
things
we're
are
all
not
here.
waiting for that. Guys, don't have any trouble waiting for 2 minutes, no? not opened it for online. So we were paying for it. But now that we have the hybrid model, plus there was a very urgent and very sincere request from ASMA that the entire proceedings should be videographed and recorded. They aim to put it up on their website as a public video. We are taking multiple requirements.
इथे बघा ना, हे करून टाकू ना, मिनिमाइज करा ना इथून वरती घ्या इथून वरती इथून name intonations, hide video panel, again hide floating meeting controls. Yes.
Thank you for that quantum of knowledge, sir. We now continue with the second speaker, Advocate Milan Salunke, who will be discussing on defending medical legal cases in the court of law. Sir has done his BHMS, Diploma in Hospital Administration, MBA, and law as well, a practicing advocate and a medical legal consultant. He provides advocacy to medicos, healthcare institutions, and various associations of doctors since the year 2007. He is involved in defending various doctors, hospitals before various consumer courts, civil courts, criminal courts, and quasi-judicial bodies like state medical councils and others. He has rendered services as legal consultant and special advocate on panel to the Pune Municipal Corporation. Sir.
Good morning. I will directly start up a lecture without much formalities because already we are there is scarcity of time. Friends, today I am here to have discussion on the topic of what different types of medical legal litigations are there and how those can be fought successfully in the court of law. Friends, before understanding the concept of types of litigation, let us try to understand in a nutshell what legal framework is in existence, which is regulating the registered medical practitioner or service provider as such in his individual capacity, and the healthcare organizations and institutions which are to be regulated by the set of legal framework. May I ask question to the people from audience? Anybody is from the allopathic stream? Yeah. Can I know the name of act which is regulating your profession? No. Those are ethics. Okay, who are from Ayurveda, Unani, Siddha stream? Yeah, name of the act which is regulating your profession? Homeopathy? Anybody is from homeopathy stream? Nobody. Yeah, act regulating your profession? We have got various the specialties, various people are coming together rendering healthcare services. Each one stream is regulated by special statute. For allopathic people, we have got recently act called as National Medical Commission Act of 2019. Initially, it was Indian Medical Council Act of 1956, which is repealed and replaced with National Medical Commission. For regulating Ayurveda, Unani and Siddha, we have got act called as the Indian Medicine, the Central Council Act of 1970. And for homeopathic people, we have got act called as the Homeopathy Central Council Act of 1973. So these act in nutshell regulating the individual professional from that his particular stream. The set of acts which are there regulating the hospitals and healthcare organization. Say for instance, Clinical Establishment Regulation and Registration Act of 2010, not in existence as far as Maharashtra is concerned. For Maharashtra, we have got Bombay or Maharashtra Nursing Home Registration Act of 1949. The sets of acts which are regulating both the individual service provider as well as the organization or the infrastructure or wherein the facilities are provided. Say for instance, PCPNDT Act, regulating organization as well as the service provider working therein. Transplantation of Human Organs and Tissue Act, recently amended in 2011. The Drug and Cosmetics, Biomedical Waste Regulations. Then recently enacted ART, Surrogacy, then MTP. So those sets of acts are there which are regulating individual service provider as well as the organization wherein services are rendered. After understanding this, now let us try to understand and analyze what various types of medico-legal cases are there in existence. And after defending the doctors and hospital in various courts, we could now classify the all medical legal litigations in three classes. The first and foremost, the medical legal litigations initiated in the criminal courts, the medical legal cases in civil courts, including consumer courts, and third one is before quasi-judicial bodies, including the state medical councils. Out of which the first would be the criminal litigations. And friends, again, criminal litigations, all medical legal cases can further be classified in two sets. The criminal medical legal litigations can be classified in the two bunches, in two classes. The first, the criminal cases filed against hospitals and doctors alleging medical negligence. And another bunch would be, and of course that would be filed necessarily under, as sir has rightly mentioned, under one section of Indian Penal Code, that is section 304A of Indian Penal Code out of 511 sections. The another classes of the criminal medical legal litigations would be cases filed against the doctors and hospitals under various statutes, including PCPNDT, MTP, the Transplantation of Human Organ Act, Biomedical, and the Nursing Home Registration Act, and other acts. So majority of the cases filed in the criminal courts for medical negligence, and another cases, the types of cases would be filed under the special statutes filed against the doctors or the hospitals in the criminal code. The medical negligence cases, as sir has rightly mentioned, necessarily would be filed under section 304A of IPC. But this is general rule. Exception is also provided because majority of the cases which our firm is handling throughout the state of Maharashtra are filed and defended under section 304A of Indian Penal Code, which is bailable, cognizable, non-compoundable, punishable up to 2 years of imprisonment, triable by judicial magistrate first class court, which is the lowermost court in criminal hierarchy. Matter is very easy. to defend such cases. Another types of cases wherein medical negligence is alleged, however, the charges are filed under section 304 part 2. Now, what is it? 304 part 2. The act is done with knowledge that that act is likely to cause death. However, that act is done without any intention to cause the death. Culpable homicide not amounting to death. Right now, 2 trials I am handling, defending 2 doctors before session court, because 304 part 2 is sessions triable. That is appellate court at district level. Triable by session court, punishment is 10 years, non-bailable, cognizable, non-compoundable. Culpable homicide not amounting to murder. One case from Aurangabad district wherein the doctor was involved, gynecologist was involved in performing cesarean section operation. After 3rd, 4th the post op day, patient started developing fever, shifted to Ghati Hospital, Aurangabad. Patient was kept in isolation ward, treated for a fever. Succumbed on 5th day post op. EM was conducted, 8 liters of pus and mob was found inside abdominal cavity. The committee gave opinion of gross negligence. As gross word was there, the police filed the charge sheet under section 304 part 2. We took anticipatory bail. Now the matter is kept for framing the charges under section 227, 26 and 27 before session court. We are going to argue whether is it fit case wherein charges can be framed either under 304A or 304 part 2. But I am sure and confident that we will succeed in convincing session court. Even if we accept entire case of prosecution as true and correct, still charges can be framed at the most under section 304A, and I'm sure that session court would again send that matter back to JMFC court for the trial, which would be easiest trial. We'll get one more opportunity, because if it is resulted into conviction by JMFC court, again we have got one more chance to appeal in session court, then after High Court, Supreme Court. At least 50 years will get passed, and let us see afterwards what happens. And so many other defenses are there. These are real defenses which we take in the court of law. Other defenses are also, madam, there in that case. Keeping patient in isolation ward by government hospital and not doing sonography or necessary investigation for 2 days and allowing patient to die due to septicemic shock is also negligence. That is very good defense, and I'm sure that will take out of that matter something which will be decided in favor of doctor. And ultimately, this is a criminal matter. Benefit of doubt should be created while defending the criminal prosecution, and all those benefits of any doubt would be passed on to the accused. So many convicted matters have come to us, and successfully we defended at the session court level. In exceptional circumstances, 1 or 2 matter has reached up to High Court. So out of 90 conviction, if 1 or 2 matter goes to the High Court level, then we are too much satisfied and confident that majority of the doctor got relieved at the appellate court the session level. So again, coming back to the points, 304A and 304 part 2. So this is regarding the medical negligence. As sir mentioned that mens rea in section 304A, Honorable Supreme Court has specifically expressed its view, proceeded to classify civil and criminal negligence in Jacob Matthews' case. Though the word gross is not mentioned in section 304A, but it should be interpreted only in the circumstances wherein negligence is gross, then only section 304A would get attracted. Otherwise, the rest of the negligence cases can be filed and can be asked for compensation by way of filing complaint and asking for the compensation that would be amounting to a civil criminal negligence and not the criminal medical negligence. Matter to fall under the purview of criminal medical negligence, the negligence should be and must be of grave nature, should be of higher nature, then only it can be nomenclated as a criminal medical negligence. Otherwise, the rest of the medical negligence can be taken care in the consumer or by way of compensation. How these complaints are being filed? And friends, the relatives of the aggrieved patient may approach the nearest police station by way of filing complaint in the police station. If police, they do not take cognizance of what remedy is available, they can approach judicial magistrate first class court by way of filing private criminal complaints. Again, two further remedies are provided there. If the criminal JMFC code is satisfied that prima facie there is a substance so as to take cognizance, then order of process issue would be passed, wherein the doctor would be summoned and would be forced to defend entire trial. Another remedy, JMFC can pass order below section 156 of 3, wherein the judicial magistrate first class court can direct police for doing investigation. Then that private complaint would be converted to the state case. So by these two ways, the criminal machinery can be put into motion as far as medical negligence matters are concerned. The other criminal matters, say for instance, the PCPNDT Act, whether police are empowered to take cognizance. If any private person or appropriate authority approaches the police station and files the complaint under the provisions of PCPNDT Act, is it maintainable? Answer is no. Under section 28, only JMFCs are expected to take cognizance. Under section 28, only and only appropriate authority or authorized officer is expected to file complaint under the provisions of PCPNDT Act. After conviction, one doctor from Bhusawal, Jalgaon district, approached me, submitted file wherein judicial magistrate first class convicted that doctor for 3 years of imprisonment. We appeared in the session court, appeal was filed, and it was fought only on one technical ground, that appropriate authority filed complaint in the police station, police completed investigation and filed charge sheet and resulted into conviction. Only on this technical ground, the sessions court had no alternative left than to acquit the accused. Only on one technical ground. He is acquitted within the period of 3 months from the date of conviction. So necessarily complaint should be filed before judicial magistrate first class, the judge, as a private criminal complaint, otherwise than on police report. Because when police report would be there, if complaint is filed in the police station and after doing necessary investigation, primary investigation, the polices are submitting charge sheet in the court, then it would be the police complaint or state case. Now the complaints filed under the PCPNDT would be the private complaint otherwise than on police report. PCPNDT, the IPC section 312 to 318 necessarily would be filed in the police station. After doing primary investigation, they will submit charge sheet. And if case is triable by session court, say for instance, section 312, miscarriage, again 2 parts. First part, 3 years imprisonment. Second part, 7-year imprisonment, miscarriage with consent. Section 313, miscarriage without consent, amended, imprisonment for life. Section 319, the 14 death while miscarriage with consent, 10 years of imprisonment. 14 without consent, life imprisonment. So depending on the quantum of compensation, which court is competent enough to try, entertain, and decide case, to decide that entire proceeding is provided. So also under the annexure provided in CRPC, before that section, it is provided that which court is competent enough to decide that case. Now, there is a concept of preliminary inquiry, which is incorporated by Honorable Supreme Court in one case judgment which Sir has rightly discussed, that is Jacob Matthews case. Before 2005, before Jacob Matthews case, scenario was totally different. Filing complaint against the doctors were arrested, produced before the JMFC court, released on bail. Next day, huge news is circulated for increasing the TRP. At the end of conducting trial, doctor exonerated. But what about his tarnishing of image? Frivolous complaints. After studying this entire scenario, Honorable Supreme Court has provided legal immunity and shield to all medical professional and entire medical fraternity. Concept of preliminary inquiry is introduced first time, and it is mandatory to be followed unless Parliament come forward and to enact such preliminary inquiry sort of principles and legislation. But till then, Jacob Matthew would supersede and would be the law of land. What it says, doctors should not be arrested ordinarily unless certain exceptional circumstances are there. Then preliminary inquiry should be conducted. After collecting the primary evidences, including medical record, documents should be sent to the nearest government hospital, preferably a government hospital. Independent, the opinion should be sought. If opinion comes in favor of doctor, case should be closed then and there only. No further the proceedings are required. If opinion comes against the doctor, then only charge sheet is submitted in the court for further inquiry. So this is the preliminary inquiry is expected to be conducted in each and every case of medical negligence, though it may be the private criminal complaint, or though it may be the police complaint, wherein the police are expected to investigate the matter. So preliminary inquiry is must and mandatory. Now, is there any concept of limitation applicable as far as all those the criminal proceedings are concerned? Answer is yes. And for that, we have to peep into section 467 to 473, friends. What those bunch of sections says, in nutshell, if any act or offense is providing the punishment only in the form of fine, then complaint should be filed within the period of 6 months. If fine, 6 months. Like these petty offenses are provided. One provision is there under the MTP Act, wherein only fine is provided. Complaint should be filed within the 6 months. These few offenses are there under the provisions of the Marriage, Death and Birth Registration Act. Complaint should be filed within the period of 6 months. If the offense is provided for punishment, which may extend up to 6 months, then complaint should be filed within the period of 1 year. Bombay Nursing Home Registration Act. Anybody practices or runs nursing home without any registration, as provided under section 3, punishable under section 6, which may extend up to imprisonment of 6 months, and fine, which may extend up to 10,000. 6 months punishment, complaint should be filed within the period of 1 year. Up to 3 years. Now, from 6 months up to 3 years, if punishment is there, then necessarily complaint should be filed within the period of 3 years. Beyond 3 years, no limitation is provided. In short, if PCP entity complaint, punishment is provided for the period of 3 years. Necessarily complaint should be filed within the period of 3 years. I fought one matter from the Bid district, wherein appropriate authority kept slipping for 3 years, and after 3 years and 1 day, complaint was filed. We moved in High Court, and that got quashed. only on technical ground, limitation, law of limitation. No excuses are there. Law of limitation equally applicable to consumer. Within the period of 2 years from cause of action, complaint should be filed. Now, self-proclaimed few people are saying that medical record should be preserved for the period of 20 years till the child attains the majority. For what purpose? If law of limitation is barring you for taking cognizance, is there any point expecting the court summons or court notice after the period of 15 years or 20 years for some negligence which must have happened and alleged at the time of birth? No, all these whims and fancies having no legal base as far as Indian legal system is concerned. So law of limitation, we were discussing about the law of limitation. Then most importantly, next proceeding would be in the case of the bail, how one shall go about the bail. What provisions are there? And friends, section 336 to 38, 39 are in respect of bail. 336, bail in bailable offences. Section 304A, medical negligence, being bailable offence, we need not to worry. We can claim bail as if our own right. No need to worry at all. Non-bailable offences, section 437. PCP entity. All sections are, all offences are non-bailable as provided under section 27 of PCP entity Act. Should we worry? No. Though it is non-bailable offence, we need to convince the court why bail should be granted. Application should be filed under 437 for getting bail in non-bailable offences. Maybe the MTP, maybe PCP entity Act, or maybe another act which is of non-bailable nature. Then in case of anticipatory bail, section 438 is there. I will give you example. In both the cases wherein the FIR was registered under section 304 part 2 for medical negligence. Now the session payable 10 years punishment, we approached session court in anticipatory bail and we could convince the court that, see, the allegations are in respect of medical negligence. For proving those, the piece of evidence would be the medical record and statements of doctors and staff members, which are already in the possession of investigating officer. Is it required to put us behind bar or put us in police custody for further interrogation? Because for establishing the offense, they will have to go in through the medical record, and already it is there with the investigating officer. No chances of tampering is there. And being the doctor, possibility of absconding would not be there. On those 3-4 grounds, I'm sure that the session court would grant anticipatory bail. But for going for in anticipatory bail mode, we need to get the copy of FIR, attest the certified copy of FIR. After going through the FIR, we can decide whether to go for anticipatory bail or not. In case of the non-bailable offences, but triable by JMFC court, no need to go for anticipatory bail, because we are quite confident that after arguing the fact that being this is the triable by JMFC, not by session court, no need of the sending the accused in the police custody or in the judicial custody. So depending on the allegations, depending on the quantum of punishment, we need to take the call on whether to file anticipatory bail application or not. If it is rejected in the session court, High Court and Supreme Court, both remedies are available. And last resort is regular bail. 439 is the regular bail, wherein in our experience, the 3-4 cases, one is from the Rahuri, wherein doctor was behind bar for the period of 4 months. And after filing the charge sheet, we file application. Obviously, the charges were very severe, criminal abortion, then MTP, all those charges were there. But subsequently, under section 439, bail was there. Even Dr. Munde's matter, even after 5 years, they got the bail. So that is under section 439 regular bail. But the point of arguments are totally different, because at that time entire charge sheet is filed and we'll have to go through the prima facie evidences and convince the judge how the bail should be granted in those the matters. How to defend all those the proceeding in the criminal cases again is the debatable topic. Engage good advocate having sound knowledge of defending the criminal prosecution. I will give example of one big hospital, Aditya Birla Hospital. The defending the complaint of the PCPNDT criminal case before JMFC court, engage the advocate who was advising the hospital on labor issues, resulted into conviction. Imagine the person who is labor practitioner given responsibility of defending the criminal prosecution that of PCPNDT, highly technical act, without having any knowledge. After conviction, then we file appeal in the session court, and still it is pending. In nutshell, defend that the appoint advocate having sufficient knowledge of criminal practice. Though the person is well versed with the civil side, may not be well versed with the criminal side. So these are important issues as far as the criminal medical litigations are concerned. So we try to divide the medical legal litigation for medical negligence and the criminal litigations. Next would come the civil cases. Friends, for medical negligence, the patients or their relatives have got right to avail these various remedies. They can avail one remedy by way of filing criminal complaint at a time, or two remedies by way of filing criminal complaint, by way of filing the consumer complaint in the consumer court, anyone at a time, or both the remedies at a time. It is the sweet choice vested with them. As far as civil litigations are concerned, we have seen that majority of the litigations are for compensation filed in the consumer court, and sir has rightly elaborated. I need not to go into the detail, but it would be suffice to say that initially under 1986 Act and now under 219 Act, Consumer Protection Act, the three-tier system, as sir has rightly mentioned, the the district commission, the state commission, and national commission. The jurisdiction is changed as far as pecuniary and monetary jurisdiction is changed drastically. So also the false and misleading advertisements are made offense, and made punishable for 2 years of imprisonment and fine, which makes it up to 10,000 if I'm not wrong, under the new Act of 2019. So also one bad the provision is incorporated, and we are as a representative of the hospitals in the consumer court, we are suffering a lot. Sir, I am defending one hospital in court situated at Akola. Treatment was provided in Pune, and that complaint being the patient being resident of Akola, he has filed the complaint for compensation in the district consumer at Akola. One more case is filed at Ji sir.
Other than talking about the current cases in such conference, you should, other than giving references, you can just tell what happened, whatever.
No,
I guess that must not be different.
sir, I am practicing advocate. I am here to share my own experiences. I'm not here to share what Supreme Court has, because all other speaker, non-practicing advocate who have not registered themselves with Bar Council, they are talking about Supreme Court has held this and this, and so many slides. All this information is available at website. Ample, even if you Google search, immediately you will get information. But I'm sharing the practical difficulties and my hands-on experience. No, I did not mention the name of hospital, only except one. And that was required, I think, sir. That was required. And this is the reality. And I'm handling that case. So though that matter is sub judice, I'm not disclosing anything regarding the particulars of that matter. I disclose only name of that hospital. And this is the reality. This is the fact. The point on which I was harping upon that the hospital situated in Pune, if patients are residing outside, they are empowered to file complaint at their own native. And this has happened only because the jurisdiction is created under New Consumer Act, wherein initially it was only wherein defendant resides or carries on business. But now complainant resides is also incorporated. And this is the difficulty, because any hospital from Pune, very difficult to defend case going there continuously in consumer court. So this is bad part as far as consumer the new act is concerned, which should be tackled and should be taken care of. And I'm sure that after so many litigations, it would be corrected subsequently. This one is the civil litigation. Majority of our litigation filed in the consumer court for compensation. After 15 years of practice, we have devised the special, not special, but the different type of SOP or the tactics wherein how we can defend all those the cases wherein medical negligence is alleged with the success, and filing affidavits, filing literature, all those things which we do regularly, ensuring that maximum cases of medical negligence will be decided in the favor of the doctors or hospital. Along with the consumer complaint litigations, it has been observed that litigations which are filed in civil courts also, civil judge junior division, civil judge senior division, wherein the matter is too complicated. The patients are paying the stamp duty and registration charges, and still they are filing the complaints. Right now, we are defending two hospitals in the before the senior judge, the civil judge senior division, wherein compensation is claimed in one case as 85 lakh rupees and another as 66 lakh rupees. So still, though the consumer remedy, speedy remedy is incorporated, still matters are being filed in the civil courts also. Speedy remedy, I will mention in one sentence. We have got the circuit bench at Pune State Bench. Matters which were at the stage in 2017, in 2020, which are at the same stage. And we know the various reasons why the speedy remedy has not been that much effective, because scarcity of manpower, no appointment of judges, judicial, non-judicial members, still matters are pending at the same stage which were there in 2017, 2018. So speedy remedy, whether it is or not, again, it is debatable topic. And the third and foremost, the remedy which can be available type of litigations wherein the doctors are defending the litigations before the quasi judicial bodies. Yesterday, Maharashtra Medical Council organized the hearing in 10 cases. I had opportunity to represent in 2 cases, one from Kolhapur and one from Pune. The point on which I am harping upon is this is the third type of litigation. Now it is evolving. People, the patients, relatives, they are not filing only one criminal or the consumer. Simultaneously, they are availing the criminal, civil, as well as the proceeding before quasi judicial bodies. And those proceedings would be decided as per the Code of Conduct regulation of 2002. Now, these regulations are passed under old Act, Indian Medical Council Act of 1956. Now that is replaced with National Medical Commission Act. Still, how those the misconduct are of older act, which is not in existence, which is repealed, are still in force. And friends, for that we have to go through Section 61 of National Medical Commission Act, and this is in respect of transitory provision. 4 boards are constituted under National Medical Commission: Undergraduate Medical Education Board, Postgraduate Medical Education Board, Ethics and Medical Registration Board, and the fourth one is Medical Assessment and Rating Board. Now, third board, Ethics and Medical Registration Board, has not enacted the the code of conduct, the professional code of conduct, etiquettes and ethics. Hence, under Section 61, transitory provision, the etiquettes and ethics regulation enacted under original old act, though it is repealed, are still in existence. The point on which I am harping, the quasi-judicial complaints are filed stating that, alleging that there is a violation of professional code of conduct and etiquettes and ethics. And under Section 22, the Maharashtra Medical Council is empowered to conduct hearing, is empowered to come to conclusion. If the doctor has violated code of conduct, then 3 remedies are provided: reprimanding in bitter word, number 1, warning, number 2, suspension of registration for particular time period, and third one is cancellation of registration. So far in the history of MMC, cancellation has done only of 2 doctors, Dr. Munde. Except this, majority of the doctors are exonerated, but few doctors are punished for the 6 months of suspension, 1 year of suspension. And friends, being quasi-judicial body, we have to defend those proceedings in very proper and legal ways. Out of 2 cases, now 2 cases which I represented yesterday. In one case, the MMC sent the notice along with the complaint allegations made against the doctor. The doctor replied by his own, and after receipt of the notice of hearing, he approached us. We asked him, where is the evidence affidavit? Where is the other expert affidavits of other doctor which are involved in treating the patient? Where are the medical records filed? He told that MMC did not ask. I said him simply that court would not ask you. It is your duty to prove your case. So then subsequently, during yesterday's hearing, we filed affidavit that concerned doctor, affidavit of other doctor who were involved in the managing the patient. And this how, after conducting hearing, after taking entire the circumstances, entire what we can say evidence on record, MMC would come to conclusion. And if, as I mentioned, if doctors are, if it is decided by MMC that no violation is there, then exoneration is ensured. However, while defending those proceedings, you shall be very cautious and precautious that being quasi-judicial bodies would be conducted in the legal ways and should be defended with the help of good person who is well versed with all those the proceedings. So this is in nutshell these different type of proceedings and how we can defend those, keeping in view the noble medical profession. So any questions, any queries? Thank you.
Request Dr. Rajendra to present the minister with the momentum of delivering such an Indian talk. Thank you, sir. Are you feeling your concentration to be stretched a little by now? To your rescue, the tea break is in effect till 11:30 hours, after which we will begin with our next talk. The tea will be served right across once you exit from the hall on your right. We come back here at 11:30 hours.
ये तो देखो मत चलाओ लैपटॉप बहुत स्लो है वो वाला यूज करूंगा वीडियो वगैरह डाल दूंगा वही करेंगे हे कुठले स्टँड आहे तुमचं नाही ले लीजिए सर उधर
मानी मान जो इधर स्पीकर रुकेगा ना उसको लगेगा जब निकालते पूरी फिर सुनते तो ये ब्रेक है ना हाँ उसके बाद भी मिल
आफ्टर लंच ठीक है
सबने प्रेजेंटेशन भी देना है मैंने अंदर यहाँ पे रख दिया अभी फॉर द टाइम इसके अंदर
अभी कोई ग्लिचेस तो नहीं है ना हिमानी सब ओके है ना
हाँ अभी अंदर कोई प्रॉब्लम नहीं है माइक है सब है
मेल करून टाका प्रेझेंटेशन. एक काम करते हैं ना, ये पेन ड्राइव से प्रेजेंटेशन इसमें स्टोर कर दो.
चाहिए ना, वो लैपटॉप पे चाहिए प्रेजेंटेशन. हाँ, मैं मेल कर रहा हूँ उनको. हाँ, वो गूगल ड्राइव पे अपलोड कर दो या मेल कर दो. नेचुरल डिफॉल्ट वो तो 2 सेकंड में आप डाउनलोड कर लो. मेरी ईमेल आईडी है तो आपकी.
Hi. मजे में. तुम बताओगे मैं how am I doing?
The phone was not switched off.
We called you to check if your phone was switched off.
Oh, thank you so much.
लेकिन आपके लैपटॉप का डिस्प्ले नहीं आ रहा है ना सर. क्या कर रहे हो? चाय पिए?
एक तो लो, जल्दी लो.
जल्दी जल्दी जल्दी।
That's fine. थोड़ा स्पेस दो। गिरीश सर, हिमानी मैम आप आ जाओ ना, उसको दो ना कैमरा। तो पूरा लेना है तो इधर आ जाओ, शायद इधर आ जाओ उधर।
मैं नहीं कर पा। करता हूँ मैं। रुकिए, just a minute।
कुछ हेल्प चाहिए तो दीपेन से हेल्प लो।
उनका क्या कहना है कि हमारा लैपटॉप स्लो है स्लो, ऐसा नहीं है कि स्लो नहीं है, लेकिन क्यों स्लो है वो लैपटॉप, क्योंकि बैकअप का लैपटॉप है, सर्वर बैकअप का, इसमें 500 GB हार्ड डिस्क है।
अपने अपने पास और कोई एक्स्ट्रा लैपटॉप नहीं है? ट्रेनिंग वाला लैपटॉप? मैं अपना लैपटॉप दूँ फिर? मैं अपना लैपटॉप दूँ? अपना लैपटॉप देता हूँ।
ठीक है, आपका दीजिए, ये आपके इधर लगा लीजिए चाहिए तो आपको यूज करने के लिए, रजिस्ट्रेशन के लिए।
ठीक है,
थोड़ा
ठीक है। ये लैपटॉप लेके आओ फ्रंट में।
And she asked me, can you send these slides? Very nice person. Slideshow. Can it be the network problem?
No, sir, it's laptop
With
hanging.
Ganpati is just over yesterday. Can it be a network problem for the online people? Last year we had university examinations online. Some of you may have appeared also. And we were worried about the networking for them. They were writing their papers online from their own homes. Luckily, last 2 years during COVID days, fortunately for our students, we had no problem. But this can be a tough thing for the students also, for writing their papers from home. Audible hai ka?
Yes, correct. Start with this.
Ichi kurchi, 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 kurchi.
Yes, sir.
This we are done, this we are done. Yeah, this we are discussing.
Yes, thank you.
Audible now?
Yes.
Good, thank you. IEC we have discussed. We'll pass on to the what Justice Cardozo was saying, that a surgeon who performs an operation without his patient's consent commits an assault, or what is called as battery, for which he is liable in damages, except, this is to be remembered, all of you, especially if any surgical people are there, gynec people are here. IPC section 92 becomes applicable. What is the section? Nothing is an offense by reason of any harm which it may cause to a person for those for whose benefit it is done in good faith, even without person's consent. That means a surgeon has operated on a person without his consent. And will the section 92 be? We'll come to that. What is the good faith? And the situation that time prevailing in the war must be properly written on your what's called documentary proof. Has to be there with date and time. We'll discuss. I'm giving to some of the examples there. And surgeon operates without consent of the patient in an emergency. The example is here. On a dining table, a person gets choked with a fish bone and is unable to speak, breathe, or anything. What minimum can be done? Use the knife there on the table and open his trachea. It's not a tracheostomy, but open and put your finger there so that the patient will have airway. I remember I read sometimes years back, 35 years back, one of our diplomats having a dinner somewhere outside, I don't know which country, he died on the table for want of this surgery. He got choked with a fish bone. I don't remember which country and who is the name, but important thing is to save that patient's life. There is no consent available. Dining fork is there, just put it in the trachea below the thyroid cartilage and put your finger. You don't have tracheostomy tubes. Then things can be, let him breathe. I've given you some examples being a surgeon. Extradural hematoma in an unconscious patient. The coning is already appearing. The hematoma is pressing on the brain and coning with the brainstem coming up. This is a dire emergency. If you remember, Larry Contractor in West Indies was operated with that ball on Wellesley Hall stuck on the one side. He was a lefty, it was hit here. And he had to be operated there in emergency. His no relation except our team was there. And I remember when I was in Vellore, in CMC Vellore, Christian Medical College, he was brought there again when Jacob Chandy, the famous neurosurgeon of India, reoperated him again. So this was an emergency. Coronary angioplasty. There have been number of instances when a patient, while undergoing angioplasty, suddenly develops a cardiac arrest. Many of you may be knowing. 2 of my classmates have died. I can name them. One was a famous ENT surgeon of our Ruby Hall, Dr. Bide, Avinash Bide. He was shifted to the theater immediately. Operated, CABG was done, but did not survive. And one of my close relation, Dilip Kusurkar, was an anesthetist in Pune. In his memory, the anesthetists of Pune are having a memorial lecture. He also had the same problem, same hospital, but did not survive. In spite of operating in emergency, the relatives outside were informed. But where was the consent for the patient? No way. Third thing, my wife being gynecologist, I can mention this. Number of times it has to be done. The fetus hand has prolapse, prolapse outside. You cannot reduce it inside and deliver it from below. Patient has to be operated for cesarean section. Sometimes the relatives are able to be given, but otherwise there is no time. Same thing with rupture tubal pregnancy. Tremendous bleeding occurring in the intra-abdominal region. There is no hemoglobin has dropped down, BP has come down almost below 60. Some of the other patient must be opened and operated. These are the dire emergencies. But remember, there has been an instance on the patient filing a case against the surgeon for operating without my consent. And this is given very well in the book known as Final Diagnosis. Read that book if you are. And the last chapter mentions about a neurosurgeon. I think it's a UK case. Operating on a person who was picked up on the road. He took him to the hospital and operated him for extradural hematoma, the first case. And the patient, after getting up and after some time when he was discharged, filed a case against the doctor, neurosurgeon. Why did you operate without my consent? And he was already dying. Within the next few minutes, he would have been dead. But then the surgeon will have to prove to the court of law that he has operated this patient in the situation with written documents, date and time. BP going below 60. Hemoglobin dropped down to 5.6. We had operated one case in Rubial also when I was the director there. Lady came without any relatives there. We had to open her. Where was the consent? So these are the cases which the surgeon is excused by section 92 of the IPC because it offers immunity to the surgeon and practitioner to proceed with appropriate treatment even without the consent if the patient, when the patient is incapable of understanding the nature of the treatment required. There are no legal heirs. I remember when I was the administrator in KM hospital, I had to permit one cesarean section. God only knows where the husband had disappeared. He had done his work, he had gone. The madam said from the labor room, sir, it has to be done. Otherwise, I don't remember the details. I said, go ahead. As a medical administrator, you are parents of all the patients, especially medical students or all students. In our days, when we were in the hostels, our dean was our guardian because there are no parents around. So that's you must know. The case of Dr. Thomas versus Elijah, it was held that in case of emergency operation, the surgeon cannot wait for the consent of his patient where the patient is not in a fit state of mind and to give the consent. However, in Grace Kuti versus Dr. Anamma case, it was considered as a lapse and not a medical negligence. Now, this is the latest which I told you. I'm going to give you contrast 62 to 22. This is a direct copy from Times of India. Yes, on Friday. This is a direct copy from there. I written the date here, 9/9. And worth reading this case. And everything is about consent to surgery does not extend to doctors' negligence by the Gujarat High Court. The ambit of, let's read it quickly. The ambit of patient's consent to surgery cannot be stretched to cover a doctor's negligent and reckless acts. Gujarat High Court said while upholding the criminal prosecution of two orthopedic surgeons on a complaint filed by IPS officer Satish Verma, who was probing the Ishrat Jahan's encounter case when an allegedly botched hip surgery by these two orthopedic surgeons in July 12 left him lurching gait and even walking difficult. He alleged that the surgery was meant to repair, probably he had neck femur or something, fracture, meant to repair hip fracture, ended up shortening his leg by a couple of inches and so that the patient would lose the balance. The criminal case filed by the IPS officer Verma in a magisterial court sought prosecution of these two surgeons under the section 338 of IPC. What the 338 section says, for causing grievous hurt by rash and negligent acts that endanger patient's life. The magisterial court ordered the prosecution of both these doctors. To that, they went in appeal, rejecting the doctor's petition challenging their prosecution on the ground that the patient had given consent to the surgery. Justice Nikhil Karyal of Gujarat High Court said in his judgment, it's worth noting this, improper fixation of an implant was the immediate and natural consequence of the doctor's negligent act. Instead of rectifying the erroneous fixation of the implant, the doctors appeared to have misguided the complainant, that means the patient. Doctors' contention that the patient had signed informed consent form, knowing the risk of surgery the court said that the consent was for the procedure based on the knowledge that surgeon would exercise requisite skill and knowledge. Remember, nowadays we have got informed consent forms beautifully designed with this elements are there, signature of the patient, the surgeon, the two unrelated witnesses, everything is there. They are in two forms, one in English and one in vernacular of the patient, whatever language he or she speaks. Need not be only in Marathi or Gujarati, can be in the patient's language also. And this is the case from Gujarat, Ishrat Jahan versus Dr. Pandit and Dr. Shah. Now let's come back to I'll finish in a few minutes, madam. Doctrine of informed consent. This is very important. It goes without saying that a conscious adult patient of sound mind is entitled to decide for himself whether or not he will submit to a particular course of treatment proposed by his doctor. This particular entitlement is the foundation of doctrine of informed consent. That the patient is entitled to decide. It means free mind, no force. Gone are those days, angutha lagao, chalo andar. That was our housemanship. Angutha lagao, chalo andar. He doesn't know what he's undergoing. Is it tonsillectomy or circumcision? He goes inside. So those days are gone now. A doctor will not leave any stone unturned to inform his patient of advantages and disadvantages, risks and benefits of the proposed course of treatment so that the patient may exercise his right to self-determination about the proposed treatment, including investigations for differential diagnosis. It is the doctor's duty to answer truthfully and as fully as possible as the question requires when asked by his patient in sound state of mind about the risk involved. That Ishrat's case, the risk was not explained probably, that it can shorten your foot. Nobody had explained to him, and he went ahead and with the operation. So the disclosure of the risks involved is also known as the tenets of accepted professional practice, which all of us must know, those who are operating people or otherwise treating. May vary from patient to patient based on the needs of the patient. Now comes the validity of this is legal seminar. How is the consent legally valid? To be valid, the consent must be real. Once the patient had been informed in broad terms of nature of the intended treatment and gave his consent, the patient could not say that there had been lack of real consent. That earlier my student's case. Consent is not valid if it is obtained by fraud or misrepresentation as to the nature of procedure. What you are going to do must be properly explained. While doing a laparoscopic cholecystectomy, patients also be informed that sometimes we may have to open up the abdomen. Because sometimes the bleeding occurs and we are worried about CVD and all that. So we sometimes open the surgery, forgetting the portals. But then that must have been informed to the patient earlier, before obtaining his consent. This is what we do in the kidney transplant cases, unrelated donors. We take their audiovisual interview and send it to the DMER in Bombay for the permission. Because the DMER then only will give the permission because the donor is unrelated to the patient. His consent is no doubt has to be valid. This we are talking about validity of the consent. The court of law is consent obtained when the patient was under sedation is also invalid on the ground that patient consent was not voluntary. It has to be voluntary. One of the tenets of the informed consent. The court of law might test the reality of the consent critically if the patient stand in a position of authority over the patient. Now comes the most important part. Many doctors ask us this question in various conferences and otherwise. Refusal of treatment. We sometimes take Dharma signature and let the patient go home. But one of those patients can take us to the litigation to the court. because that doctor gave us a inefficient or insufficient treatment by not doing my surgery. He forgets to tell the court that he has not given the consent. So what is our proof as a medical person? You must take it in writing. A competent adult is entitled to reject a specific treatment, even if the decision may entail risks as serious as death. A doctor cannot disregard the patient's advance instructions. Consent is implicit in the case of a patient who submits to the doctor, and absence of consent must be made out by the person alleging it. When a surgeon advances a plea that the patient did not give his consent for surgery, the burden is on the surgeon to prove that non-performance of the surgery was on account of refusal by a patient to give consent thereto. Patient is already gone. The MI is signed and gone. Have you taken his refusal consent? That must be in the papers on the medical records, at least till the act of limitation is over. It is further advisable that refusal of surgery or treatment, even treatment. Many times today, patient also refuses our treatment and goes to somebody else. He's agreed, no, but give us in writing. It must be obtained, and two unrelated witnesses must be there. In our clinic, there are so many patients waiting, relatives. Take the signature. Why patient should be taken in writing in the interest of our own. Our own interest must be safeguarded. I would like to conclude, madam. Thank you so much. In the words of ex-Chief Justice of India, Justice Verma, be you ever so high, law is always above you. Thank you one and all for your patient hearing. Thank you so much. If there are any questions, I would love to answer if the time permits. So if you allow me to ask questions. Yeah. So most of the hospitals, when the patient is on ventilator, relatives always insist that remove this ventilator if suppose the patient is not responding. So whether law allows removal of a ventilator after taking consent of the patient's relatives. This has been common experience of mine in Ruby Hall. Dr. Grant, sir, my own teacher, KP Grant, many times he himself asked, because there are a lot of Parsi patients with no relatives around admitted with us. But does the law permits us to put off that ventilator? Who gives us the permission? The patient himself is almost gone. See, in our country, every patient has multiple relatives, this side, that side, back side, so many. You can imagine number of patients, relatives come to us, chota bachcha pan yeto, sir, mera maa ko kya hua hai? We have to explain to him also. So the relatives, what taking signature of one relation, will it be enough to say, can I talk to, there may be another daughter somewhere in England, America. Nowadays, most of our children are abroad. She will say, who gave you permission? Did I tell you? You have done a fault, then there will be a litigation against the hospital and us as an individual. Sir, in my own opinion, you are more experienced than me. I said no to your grandson. He was my teacher. I said, sir, beg pardon, but let's not do it. He had gone one step ahead and asked me, Bokil, can I take his signature? He's unconscious, he's on ventilator, on his will. I said, how can we? Because he doesn't have mind now. Will should be written by every individual when you are conscious. Your sound state of mind. At least mentally you should be sound. Physically you may be invalid. So these are the things which are common problems of our administration, and I have experienced it number of times in both the hospitals, KEM, even abroad also. I worked in Middle East also, in Bangladesh also. I had to study their laws first. and then accordingly handle it. So to answer his question, in your own interest, because there can be 3 doctors, 4, who knows how many doctors, officially, unofficial, may be there. Who knows? We cannot put off the ventilator and don't do it. Let that time. There have been number of instances in medical records. If you go, the people have woken up after 2-3 months of unconsciousness. Who are we to do? Yes, madam.
Sir, I'd like to share with the House as well as both my esteemed speakers that we have a session on end-of-life decisions.
Yeah, yes.
Let's
Okay.
wait for that session.
Walke is also
Let's
is
wait
here.
for that session,
Yes,
right? So
Okay.
let's wait for that session for answers.
What do you want to ask?
Good afternoon, sir.
Good afternoon.
Many times we have seen while we work that patient have reached to their terminal stage and we have explained guarded prognosis. So what happens? The palliative care concerns are being taken from the relatives. Now my question is, when we give the discharge summary, do we have to mention that palliative care consent has been taken, or we have to show the process of CPR or something? Because then it becomes a contradictory in the both of the consent and the discharge summary. So what is the process, sir, in that case, sir? Because we can mention, I guess, in palliative care consent taken.
Exactly. You should visit the Cipla hospital in Pune. It's worth visiting there because they mainly treat the terminal patients in the cancer cases, at least for 15 days, so that their relatives get acquainted how to look after them at home. So my advice, because unless the patient is health insurance covered, because the records will go to the health insurance, in that case, palliative word will have to be omitted. Because if you are putting him on ventilator, you are given active line of treatment. Because if the patients, because people are bound to go to the, because I am a consultant to many health insurance companies, I'll ask for the case papers before I give my opinion. So that is likely because this is conflicting one to other. So remember, the palliative word will have to be dropped in that case while writing the discharge summary, especially in health insurance cases.
Okay, sir, for that wonderful.
Thank you, one and all. Thank you so much.
I request Colonel Saroj Patnaik, Deputy Department of Hospital Administration, AFMC, to present Dr. Pandurang with a memento for delivering such an elucidating talk.
लग हो गया आपको ओपन ही रखनी चाहिए थी यस इसका वो भी होता है वो भी ओपन करके रखता हूँ
He's also on the panel. He's left. He's also on the panel. So which one? He's also left. वो भी नहीं है और बाकी सर्वे में तो अब 6 के लिए 4 लोगों का पैनल है आगे का समझ and Melissa is also not. He's not on the panel. So ये 4 लोग करेंगे panel discussion तो अपने आप कम हो जाएगा. And I told them to wind up by 2 o'clock.
Which screen?
I now invite a whole host of our speakers for the panel discussion on legal and ethical interface between pharma industry and the healthcare professionals. First up, we have Colonel Dr. Saroj Patnaik. He's an MBBS and an MHA from AIIMS, New Delhi, has served for more than 25 years in the Indian Army, part of the United Nations Peacekeeping Force in United Nations mission in Ethiopia and Eritrea, executive editor of the International Journal of Foundation of Hospital and Healthcare Administration, member of the expert committee constituted by the Ministry of External Affairs, Government of India, to prepare the technical project report for the Bhutan Institute of Medical Sciences, instrumental in drafting the National Ambulance Code, has set up a 1,000-bedded COVID hospital in Delhi and 500-bedded hospital in Muzaffarpur within a fortnight during the COVID pandemic. Currently, Professor and Head, Department of Hospital Administration, AFMC Pune. We welcome you, sir. Next up, we have Group Captain Dr. Teju Murtala Venkata Satya Venugopal Krishna Tilak. Not my fault, sir, ma'am told me to. He's an MBBS and MD medicine from AFMC Pune. He has done his DM in medical oncology from AIIMS, Delhi. He's a fellow of the Royal College of Physicians, Glasgow, having served in the Indian Air Force for 25 years and counting. Has set up the Bone Marrow Transplant Center at Kaman Hospital, Air Force, Bangalore, involved in setting up of 2 DRDO FMS COVID hospitals at Delhi and Patna in 2020. Currently, Professor and Head of Department Geriatrics at AFMC Pune. We welcome you, sir. Next up, we have Mr. Vivek Padgaonkar. Sir is a postgraduate in Science, Diploma in Management Studies from Mumbai, Diploma in Training and Development from Indian Society in Training and Development, former Glasgow and Sales and Kind and Sales and Marketing, founder of Paddy Advisory Services LLP, and is an advisor and consultant to MNCs and Indian companies in pharma and medical device sectors in the areas of pricing and regulatory matters. He has a substantial exposure in lobbying with think tank organizations on healthcare issues with the Indian government and made significant contributions in shaping current pharma policies, particularly the National Pharmaceuticals Pricing Policy of 2012, the Drug and Price Control Order of 2013, and the Uniform Code of Pharmaceuticals Making Practices. We welcome you, sir. Lastly, I would like to also reintroduce Dr. Santosh Kakre. He is, so you may. I will moderate this. Sir. With this enlightening panel in place, we now begin with our session.
So good afternoon to all of you. Howdy. Perfect. That's a great thing. So all of us had done the responsibility of moderating this session has been casted upon by the Colonel Kashyap Madam upon me. I think this is an opportunity to discuss a very important session, very important topic for mainly the hospital administrators and those who are from the medical field. Just to tell you, when I started my practice as a surgeon, It was first experience that a medical representative from some company, he came and started detailing. I came to understand that whatever I have studied during pharmacology, he is telling something different to me. And then that is the way by which he updated my knowledge. So this is one of the area where after getting your degree, when you start your clinical practice, your knowledge of pharmacology is based on whatever the medical representatives tell you and teach you. And really speaking, the doctors, the clinical practitioners, they depend on the medicines, newly introduced medicines, various fixed drug combinations, and whatever the new products which are coming in the market means which are available to the patients as such. So every knowledge comes from the representatives of the medical or pharmaceutical companies. So without the interaction between the two fields, that is the clinical field, that is medical practitioners, and the pharmaceutical industry, I think there must be a synergy between these two fields, so that in the interest of the patients, actually the patients are consumers, I have already told you, but in the interest of the patients, the kind of an interface that exists between these two fields is very interesting, and everybody who is in this field must understand what are the ethical aspects and what are the legal aspects of these interface. I remember that during the first year of my practice, many of the medical representatives came and met me. Some of them, they promised that you will get money. Now I'm just sharing this with you. So not only myself, but many of the doctors, they are getting this experience. Some of them promise that if you write these medicines and drugs, these will be the benefits which you will receive. Of course, this is a kind of a marketing strategy. So whether it is ethical or not, that we are going to discuss. Another issue is the pricing strategy of the pharmaceutical companies. So when you come across number of drugs, be generic or even the brand name drugs are there. So which drug you need to write as a doctor? So that also one needs to understand. Then whether branded drugs or generic drugs, they are more effective and more useful. So that one has to understand. Another point and issue. So these are certain subtopics which have been chosen for the panel discussion. I'm sure the whole of the list of subtopics, if we want to discuss, it will take probably 1 or 2 days. So only selected topics have been selected, and the esteemed panelists who are present here, they will be presenting their views on that particular topic, and then we will be discussing. See, it is not only the panelists who will participate, but you all will participate. So this panel discussion is a kind of a group discussion in which you also will be contributing. Now, since Dr. Machwe, who is a clinician, he is not there, I actually request Dr. Walke, who is a gynecologist, who should actually participate, and he must share his views. I think you can come and sit here, please. Thank you, Walke sir, for accepting this particular invitation. And actually, I also wish to invite Colonel Surekha Kashyap madam, because there is no ladies representation here.
In accordance with the New Drugs and Clinical Trial Act 2019, in Ethics Committee, you need to have one lady member.
I don't know whether I am happy or sad at being included because of my gender. Because my whole life and my whole career has been spent in making my gender irrelevant. So I accept it in all humility for whatever reason you have invited me. Thank you.
Of course, as a moderator, I'm going to give her more responsibility that you will now see during the discussion as such. So now, let me invite as a first speaker. Actually, my preference is to Dr. Tila. She is going to talk on the generic or branded medicines, because this is very, very important and essential topic which everybody must know. So, in his introduction, one very important aspect which was not shared, which I'm going to share with you. So that is, recently we have come across a flashing news that in a flight, life of a cancer patient was saved. And it was this gentleman who saved his life. So he names a standing ovation actually. Everybody must stand and so let me request Dr. Tila to proceed and discuss this particular topic.
Thank you, sir. Thank you for the kind question. And I think it was purely the hand of God. I would say that this happened on flight. It was lucky that she survived despite being a stage 4 cancer patient, and we handed over safely at Calcutta. Thank you for recording that incident. So talking about generics, or should it be branded medicines? A lot of research goes into so the kind of so-called molecules or chemicals which come into a discovery area. About 10,000 of the molecules or chemicals, depending on it's a biological or it's a non-biological agent, only about 5 to 10 eventually reach the stage of clinical trials. So out of the 10,000, 250 odd reach somewhere the animal trials, 5 to 10 of them reach the clinical stage, and of which only 1 or 2 eventually get marketed as a particular drug. So you can imagine the amount of money which goes into drug development, and thereby probably the branded drugs do have their share of their proprietary rights, and as well as their kind of patent issues or exclusivity rights, what they call it for themselves, for use in the market. Having said that, the problem with that comes is the cost of the branded medicines, and that's why the generics came up. Somewhere in 1984, the US government passed an act known as the Hatch-Waxman Act, and this act gave clearance to most of these companies to start preparing their drugs, which they could bring into the clinical practice without use of animal trials and without use of any drug discovery procedure to be shown for approval of the drug. So that took away entire amount spent by these generic companies. Based on the originator molecule, they could show bioequivalence or pharmaceutical equivalence, right? And there are values for that, and they could come into the market. And since then, the generics has completely reshaped the way we use the drugs in our clinical practice. India currently is the 3rd highest producer of medicines, having a huge share of 60% of generics world over. Almost 75% of the drugs in US are generics from Indian market, and a large share of the Indian pharmaceutical companies by generics. So what exactly is a generic? The WHO has got a definition for generic. The FDA has got a definition for generic. The WHO has predominantly 3 main pillars of definition. One is the intention of use. Second is the manufacturing, and third is the marketing. So a molecule or a medicine which is intended to be used interchangeably with the originator molecule, which is manufactured without the requirement of a license by the originator drug, and which is marketed after the end of the patent or the exclusive rights of the originator molecule. These three are included in the WHO definition, whereas the FDA names the generics as a drug or a molecule which is used, it has got a same kind of strength, same dosage, same route of administration, same pharmaceutical effect, and an intention to use. If these are satisfied, it becomes a generic. Right? The cost of generics is significantly low as compared to the originator molecule. Almost 50 to 80% drop is there in the generics. Why should generics? Is it good for the society? Generics are good for the society because for two reasons. One, it brings down the cost of the entire molecule which is being used. Number two, it kind of brings into a competition, thereby allowing the originator molecule also to drop its costs. So with that, the originator molecule costs have dropped. We have seen it very often in, especially I'm a practicing oncologist. So we see it in the original molecules which come up, the targeted drugs which come up, they are extremely costly. And as long as the patented and the exclusive rights are available, the drug is almost nearly very difficult for a person with out-of-pocket expenses to use the drug. And in India, almost 70% of the people actually have out-of-pocket expenses. Very few of them have health insurance. So only when the patents go away and the generics come in, we have seen a very good effect of the use of that particular drug. However, in the Indian scenario, there are issues of the safety, the efficacy of these generics. Though there are laws, there are the 1945 Act of the, I think it's the Drug and Cosmetics Act of 1945. There have been revisions to that in 2016, 2015, where they have asked for some kind of bioequivalence to be made available for a generic to be marketed. However, in 2016, I think they said that even if you're able to show in vitro equivalence, you need not show clinical studies. In vitro equivalence, for some of the drugs, you can use them as generics. There is an issue of regulatory authorities to clamp down upon the drugs which are being made illegally in the country. So that is one aspect of the Indian scenario where generics need some amount of regulation. And apart from that, whether branded or generic, is it ethical? The amendments in the Acts of Prescription now make it very clear that the doctors have to write the generic name of the medicine and only say the brands. Can a doctor not write brands? Because we know that we are comfortable with some brands. You know, I have an experience of this particular brands of medicines. How do they act? How do they make an effect on the patient, etc. So, am I wrong in writing brands? No, but I have to write the generic. I can suggest brands to the patient because I know the effect of that particular one. Now, why is it important? Because drugs have got an active ingredient and have got an inactive ingredient, what you call as excipients. These excipients have been like saccharose, lactose, etc., which are added to the medicine, which the generics use different from the originator molecule, which sometimes cause side effects to the patients. For example, there was a medicine which had lactose, one of the antiarrhythmic drugs. The generic brand had lactose as one of the excipients. So this patient who was doing well on the branded drug was prescribed the generic and he developed lactose intolerance. So these kind of side effects are known, anti-epileptic drugs. So they have their effects. So as long as I know the effect of a particular brand, I can write the branded drugs, but generic is compulsory in the prescription with few brands to be given. So you are ethically not wrong in writing a branded medicine as long as you mention the generic name on top.
Thank you, Dr. Tira. Few of the questions actually we are expecting to ask him. So let me start. I will ask the first question. That even if it is highly discussed, there is a difference between generics and branded medicines. The generics are equally effective. Still, the doctors are not prescribing generics. So, this be the barrier for not prescribing the generic medicines as such.
So, there are barriers for doctors to prescribe generics. A lot of it comes from the knowledge about the particular molecule. If they do not have the particular knowledge about the molecule, or he's a provider, or the patient is not aware of the benefit of the generics. Again, the generics, he does not accept the generics. He says, I want only branded. I don't want generics. So it is the duty of the provider to give the knowledge regarding the use of generics as in. Secondly, like I mentioned, there is apprehension that a particular generic may not have the desired effect or may have adverse effects which the provider has already experienced before. So he does not want to use the generics. So I think these are the 2 or 3 main reasons why the generics are still, there is an apprehension to write the generic and rather write the brand of the medicine.
Suppose I decide to switch from a brand or branded drug to a generic medicine. So is it beneficial to the patient, or how that can be possible?
That's another good question. That if a patient is not able to bear the cost of a branded drug, should we change his medicine? So I would place it as it should be individual disease specific and the patient specific. For example, anti-epileptic drugs, though the molecule may be same, we have seen in our own clinical practice where patient throws a seizure at the, when change of medicine, especially in our kind of setup, in our medical stores, and medicines come at different, pricing strategies. Sometimes the same brand does not come, same company does not come. And we do see patients who throw up a seizure despite being controlled on a particular medicine. There is a case of such nature. I think it was GSK, the lamotrigine, which had the patient recurrently through seizure. The medicine was eventually changed or something of that nature. So if care is to be taken regarding the use of the excipient, we should be aware of what all excipients or the non-active ingredients are there in the medicine. Care should be taken which disease we are taking while changing between generic and branded. Both the parties should be aware that yes, a medicine is being changed, and with this care, we are allowed to change branded to generic or other way around.
Thank you.
Okay, can I also ask a question?
One question we will allow.
Okay, just because we come from a hospital which has to sell something, if I have to make a choice and a learned choice between a generic, which would really help a lot of patients in the general ward, how would I select from out of the generics available in the market? Like, what should be the strategy in selecting one of them, which would really be a optimizing this thing in between the two?
That's another very good question, ma'am. And though the bioequivalence and pharmaceutical equivalence is supposed to be proven by these drugs before they come into the market, and there are rules for that saying that for a drug to be called a generic with a large therapeutic index, the area under curve of the molecule should be at least 90% of the time between 80% to 125% of the originator molecule. So if we can go back into the generic, the details of the drug, that what was the AUC but they have proven to come into the market, that will give us a clue that yes, it is closer to the approved strategy. For narrow therapeutic index drugs, this is even more narrow, between 90 and 111%. So that knowledge can give us a clue. That is one. Secondly, few of the good manufacturing certifications, the market turnover of the company, if these we are aware of, we will know that he is not a roadside company and is a reasonable company. With this knowledge, we should be able to choose our generics rightly.
Just want to add very important inputs due to my experience as medical stores officer in charge, where inventory management as well as optimal utilization of local purchase budget, as well as ensuring availability of medicine was all part of my portfolio, even though the LP committee was separate. But the problem was the budget was getting spent, but the inventory was not keeping pace. We were not able to procure sufficient amount of drugs, and mostly they were chemotherapeutic agents. Even common drugs were not there. And the reason was because the tendering was not generic. The tender inquiry was by trade name. I'm talking now from the purely administrative perspective. What is your job as an administrator? To make sure that the drug is available in the inventory. Number one, availability. First tenet of quality, availability. Second is quality. So how we ensured quality was that with formal permission of our bosses, they're called commandants, formal permission, we switched over to generic tender inquiry. However, in order to limit the boundary of what was quoted by the vendors, we had a formal board of officers constituting only of clinicians from all specialties and super specialties, and we requested them to give us 3 or more preferred manufacturers. And we made a basket of those preferred manufacturers, certified it, and put it on the notice board. And the vendors were registered based on their turnover and if they were holding the authorized distributorship certificate. And they were enjoined by the order of the hospital administrators to only quote from one of those approved manufacturers. So we have independent financial advisors who are like, they are ruthless. They are ruthless. We were able to sail through because we said, what's your problem? Your problem is you want to see competition. Here is the competition. There are 70 authorized manufacturers, acceptable to us, acceptable to our super specialists, generating a lot of confidence amongst the patients. The moment we switched from the trade name inquiry to the generic inquiries with the limited basket of manufacturers, not one, limited. The procurement rates fell down, ladies and gentlemen, by 50 to 60%. What we were procuring at 1,000 rupees per injection came down to 500 or 400. Same, Cipla has a generic division, Cipla has a branded division. The only thing they used to come and ask me was this, Madam, aap apni tender inquiry generic kar rahe ho ya trade name kar rahe ho? So all these multinationals came on a wonderful level playing field. We had quotations from 10 multinational firms against one tender inquiry because the name of the drug mentioned in the tender inquiry is generic. So ladies and gentlemen, I think, and because now you see the other side of it, because what we were procuring at 900 earlier, now we are procuring at 400. So we can procure double within the same financial powers. So the stock level went up. And believe me, within 3 months of this wonderful decision, we achieved 95% compliance. So as administrators, this is important for you to know.
Sir, your comments, please. Parmar, sir.
Just a little contribution what the Captain Tilak spoke about. The whole issue of the drug manufacturing molecules change after TRIPS and TRIMS that came in. Earlier it was the process patent, that process of a manufacturing a molecule was registered. And a person finds a way, Dr. Reddy or somebody else, a different process and manufactured the same molecule, he was not violating the registered value of that one. Later on, we have to adopt to product patient that whatever process that you use, if the product produced is the same as the original molecule, you have to adhere to the guarantee and warranty period. So that is the one. And the one which is said earlier, there's so many molecules get registered, but a handful of them come to a conclusion. It takes time from the date of registration of a molecule to manufacture. It is total 20 years period is granted. From the date of all the starting process to the various trials and animal trials and human trial and certification, manufacturing and available on the shelf is only 5 to 6 years are left. Within that, he has to recover the cost of the whole production because after 20 years, it is off patent. That is the one issue. But the failure cost of registered molecule is very high. So the entire cost that time I was calculating, it used to be 280 to 300 crore rupees per molecule. Now I'm told that it is climbed to 500 to 600 crore for a molecule. But this failure cost, it is after registration, you may not reach anywhere and it has to be abandoned. That cost is incurred. That's how the pharmaceutical cost pricing has this aspect also has to be kept in view. You can't say everybody in pharmaceutical industry is facing us, where this cost has been incurred. Now the cost is practically sometimes you feel the problem that I was buying a local sutures in Calcutta. We given sort of a tender inquiry for various sutures of different types or different procedures. The finer one, thicker one, this absorbable, non-absorbable. And I got a the rate inquiry has come from various people. So original people, whether it is the known one or unknown one, the Johnson and Johnson, the other people, everybody is quoted. When comparing, I found that the rate quoted by a vendor was much cheaper than the regional head of a division of Ethicon or Johnson. How can he supply the lesser cost than the registered supplier? So that sort of a shook us up that how do we go about it? Because I'm incurring this expenditure. And if I have to go for a cheaper version, or I should go to the registered known person who's supplying is an original manufacturer. Call the people to check with them that what is this difference? How can your sutures can be supplied cheaper by a vendor? He said, what are your doubts? He said, my doubts are 3 or 4 doubts. One is that it is either stolen from the government hospitals and brought and being supplied to. Is it the expiry date? The date has been changed. Surgeon will find it difficulty while suturing, it will break or something will happen. Or it is a spurious drug that has come from somewhere else and it is being given a name. With that, I called a conference and met people, and with all the presence of a specialist and super specialist and my medical store people and the vendors, they said, I am going to re-tender it. And then you see, with this knowledge, re-tendering was done. Those vendor which was cheapest did not apply, and I have to give a contract to the original manufacturer representatives. So this can happen practically. I just thought that this is the issue that may come up in your practice physically. You should be aware of those issues. Thank you.
Thank you, sir. It's a great experience which you have shared with all the audience, and I'm sure being the future hospital administrators, they will remain vigilant and they will remember this particular sharing of the experience, and every process will always involve some kind of a research which practically you should do and then proceed ahead. I'm thankful to all the participants who have spoken. Here, I'm reserving him for the final moments. And so he is the one who is the man from industry. And as a reason, we will expect something more and more contribution from him, but at the end. So now let us move on to a second topic, which we know that. Yes, please.
You had said about procuring the drugs from same company, the supply you said, and there was a great price difference. That is what is the exact, I think, barrier for layman.
The layman can't get that much of rate, and therefore doctors they don't prescribe generics, because the generic MRP as well as the standard MRP is the same, and therefore doctors feel that the generic should not be prescribed.
Prescription, as you heard, the law. Now we'll go law. When there is a conflict, law comes in. What is the law?
Then the point is,
the law is that the prescription has to be in the generic name, but the doctor can write in bracket the preferred brands. The problem is in India, when I was talking, the experiences of a public sector, government, defense procurement. Defense procurement enjoins competition on us. It prevents us from buying any medicine on MRP. The patient is paying nothing. When the patient is paying nothing, the organization is strong. We have standard operating procedures for procurement of medical stores. It is an organizational strength. That strength is not there when the patient is buying out of his own pocket. He gets fleeced everywhere.
I agree on that point, ma'am. I'm referring to the points which we were discussing earlier. How about a general person, layman?
He knows because the doctor has given him 3 best choices. He relies on the doctor's recommendation.
Agreed, madam, but the MRP which is printed of the generic C1 is equivalent to that of a standard one. And that's a great problem.
The pricing answer is coming from the pharmaceutical industry.
Yeah, that is true. Yeah. I think that was the main barrier for doctors prescribing a generic version.
But then, sir, your concern is absolutely perfect, absolutely right, because this is faced by the doctors as well as patients as such.
Patients as such.
How to know which drug should be actually bought. So that's also a point which we will just keep it here and then we'll proceed ahead. Sir, you want to comment something?
This issue of this, that they, while practicing in the corporate hospital, they come to some decision because there are issues on the choice of the doctors, cost of the medicine, original manufacture. So while driving the formulary preparation at Bhubaneswar or at Bangalore, we went for a consultative arrangement with all these clinicians, super specialists, to everybody, that we will draw for what you prescribe. We made 3 drugs will be listed for each item. Original molecule, popular molecule among the specialists, and the cheapest generic molecule. All 3 will be listed. All 3 will be available in the hospital. So depending on the choice, you can use any of the 3. Everything was listed based on this: the original molecule, choice molecule, and the generic.
That's a great take. I think being future hospital administrators, we will definitely remember this. And we move on to another topic. And I see we'll have to wait till 5 p.m. there
One last question.
for your lunch. Yes, please.
So we have considered the doctor's point of view and the pharmaceutical point of view. But what about patient's insurance company? I have a question for you. So if I take generic or branded, will my insurance company cover both? Like sir said, we have 3 options. We can keep all 3 in hospital. But what from insurance point of view?
So the policy which you have taken, that will give out the details. In such cases, there is one thing, something known as branded generics. So the same company which makes the branded item has, in collaboration with another company, gives its own molecule, but a different name. For example, there's a drug called trastuzumab, which is used in breast cancer. The original company was Roche. They made it as Herceptin. Now, they did not allow anybody else to use it. For 10, 12 years, it was just Herceptin. Then they gave rights to another company. They said, okay, we will make it a generic. We'll send it a different name called Biceltis. It's much, much lower. So you're using the same one, but branded generics can cover up this small gap of the insurance clearance.
Thank you, Dr. Tilak. Now, let's move on to another topic, which is quite important, and Dr. Patnaik is going to speak on that particular topic. We all are concerned about the prices of the drugs, mainly the patient's pockets, and even as it was just now discussed, Madam has discussed that there is definitely constraint on the budget of the hospital. So how to actually go about that? It was discussed nicely, but then whether it's possible to cut down this price or capping of the price by the government. So on this particular topic, Dr. Saroj is going to throw a light on it. I request him to go ahead.
Thank you, sir. So what I'll be discussing with you all is about the pricing strategies and whether price capping that is being practiced in our country, how is it standing as far as the end consumer goes. So to start with, India is called the pharmacy of the world. You'll all be very happy to know this. Our country is the pharmacy of the world. As Grupi Tilak rightly brought out, 3% of all the drugs that are produced in the world, they are produced by volume in India, and 4% of the value addition also comes from Indian factories. You will be surprised to know that out of USA, FDA approved manufacturing units, more than 2% of those units are in our country. And we are the largest producers of vaccines, which was proven during COVID times also. So with all this background, once you get down to the pricing part of it, there are studies in the world. At the outset only, I am stating this, that the pricing that is there in our country is minus 78%. I repeat, minus 78% of the median pricing of what is existing in the world. That means we are already far, far below than the products that are there. Now, along with this, what is the biggest challenge? The biggest challenge for all of us is affordability, accessibility, and the quality of the medicine for our end users. In India, as he rightly brought out, the out-of-pocket expenditure is very high for each Indian citizen. As per the recent studies, it has come down to around 50%, but then still 50% of out-of-pocket expenditure is still high for any person who wants to avail any sort of healthcare from the government agencies or from the private agency. You will be surprised to know that there is an inequitable distribution of the private and the government agencies in our country. The healthcare providing agencies. Most of the private hospitals, they are located in urban areas. So the challenge is, how does one reach out to rural areas with affordable medicine? You know, price modulation of medicine is nothing new. Long back in 1975, as long as 1975, there was a committee called Hathi Committee, led by a member of parliament, one Mr. Hathi, who said and who started the process of price capping for various medicines. Subsequently, the Ministry of Pharmaceuticals that came up, that floated the National Pharmaceutical Pricing Authority, that body came into existence somewhere in 97. They took out a list of, price control orders, which has roughly 800 odd medicines that are there in that. The issue is not of getting these medicines into the order. We have to look at it that those medicines which are there, how good or how effective it is for the industry to supply them at the rates that are being quoted by the government. The government is doing its bit by capping it for its accessibility and affordability. In the process, what happens is companies which are involved in supplying these drugs, they cartelize and they just move out of that segment because it is not beneficial to them. You have heard from Tilak, you've heard from Parmar sir, what it takes to, take out one compound. So let us be realistic. If we want to have good products, we have to ensure the quality and we must pay the price. Now, how pricing is to be decided is very interesting as far as pharmaceuticals are concerned. All of us make an effort. The government is making its effort. This Ayushman Bharat Yojana that has come up, the other insurance schemes that are coming up, it is addressing a huge clientele of people. But still, there is a lot more that deserves to be done for ensuring quality drugs to each of the clientele. The interesting part about how drugs are priced, it is not out of traditional costing. Please understand. Each drug is priced as per the market pricing strategy. Now, what is market pricing strategy? Market pricing strategy is the government sees that which are the drugs, the various brands of the drugs which have more than 1% of market share in the country. It averages out their rates, adds up 16% as a distributor margin and launches that into the market. Once that is done, it is now at the level of distributor, how best they can provide it. This is where the actual challenge is. The challenge is at the level of supply chain management. The challenge is ensuring that this drug is available to the farthest corner of this country. With the same pricing, what government has started, which you are all aware, are these Jan Aushadhi Kendras, which have now become Pradhan Mantri Bharatiya Jan Pariyojana. Okay, so these Kendras have come, and by 2025, they are planning to open 10,500 of these Kendras across the country. But these Kendras, they have to ensure that the primary medicines that are there is available at a cost that has been decided. And this can only be done by making the supply chain and digitalization of the supply chain. People must know, with digitization, what comes? You can actually cut down on the cost of inventory. You can actually cut down on the cost of marketing. you can actually reach out to the medicines just in time. So unless these frameworks of digital medicine comes in place, it will be very, very, very difficult for us all to get to the price that is desirable. We are still way ahead from other countries, but a lot more can be done. And that is where all of us have to step in and ensure that the planning for the procurement of drugs is done ethically, and that's how your patients will be benefited.
Thank you. Let us keep it open for the audience. So yes, please.
So you have really brought out very nicely that the authority should ensure the availability of the drugs as well as to maintain the quality. I request the opinion of the panel regarding the evergreening of the patent, like what Novartis has done in I think 2006 or 8. The imatinib salt, they have done some changes, and they have asked for the evergreening of the patent. And this evergreening of the patent was not allowed in India. They said that it has not increased the efficacy of the drug. However, the Novartis was claiming that the bioavailability has increased, and the evergreening of the patent was not allowed. So the salt becomes a generic, and various people have started manufacturing it. So on one hand, we have to ensure availability and affordability for the masses. Whereas if we don't allow these evergreening of these patents, how can we ensure the quality? I mean, unless there's a constant improvement in the salt. So a balanced decision should be taken to go for the advancement of the molecule as well as to encourage the generic players to make the generic version.
Sir, any answer to it?
So this imatinib, when it was launched by Novartis, and I think early 2002, 2003, there was a time when, in fact, this molecule was discovered by an American called Brian Drucker. He did the lab research, and his face and his thing was there on the Time magazine cover, saying that magic bullets are being used. So Brian Drucker discovered imatinib, Novartis took over that and finally patented it. So they started providing this drug with a lot of patient assistance program. So all what we had to do was, that time I was in All India Institute of Medical Sciences, 2009, 10, 11, 12. We used to write the host of papers, fill out the papers. The patient used to take the papers to the provision centers, and Novartis used to provide the drug free of cost. There were around 9, 10. Initially, there was a lot of cost involved in because of patent. Thereafter, imatinib, somewhere in 2013 or something, I think they finally came out, or 12. They started having 11. They started having some more other companies which started making imatinib. We realized in our clinical practice that those patients who were taking imatinib of different generics, there was a slight bit of difference, except 2 or 3 generics which were doing very well. So here again, the choice of that particular molecule to use after a patent has been taken out lies on the provider with the knowledge which is given to the patient, and then a drug is chosen. Regarding evergreening of patent, I am not actually qualified much in that part of what they did, but if anybody else can take it.
Reserve it for sir.
Okay. Look, you asked 2 sets of questions. One is about patent, which is slightly off the topic, but having asked, it's the responsibility of the panel to respond. One is about the patent, and other is about the generic. Now look, Indian patent law is very strong. In one of my deliberations in Singapore, foreigners were talking, India patents are fraudulent, they flout the system, the false patents have been used. I said, no, India is a sovereign country, and you must respect the law if you want to enter the country and if you want to market. What you ask is the evergreening. Evergreening is not allowed. Section 3D of Indian Patent Act does not allow any evergreening. Imatinib Mezilec, as sir has indicated, was launched by Novartis. In fact, the originator, when he brought imatinib Mezilec, in 3 years of time, he recovered the cost. And then in one of the High Court proceedings at Chennai High Court, Novartis said that we are giving 97% free under patient assistance program. So I think judge was quite sensible. He said that, look, if you are giving 97% free, why don't you reduce the cost? If you are doing charity, why don't you reduce the cost? On which Novartis didn't have license, and Novartis, of course, lost the case. So if you ask me, how do you ensure that patent can be protected, and how do you ensure that the substitutes can be brought in? Everybody cannot bring substitute. So what sir has said, that reverse engineering, reverse engineering, which, what, international scenario calls that India is a, in a puppet market, a copycat market, whereas Indians say that we re-engineer the product. There always fight goes on, between the Indians and non-Indians outside the country. Fine, that's it. That's a part. But today, as he has indicated, the huge cost is involved to create a drug. How much is cost is a debatable. Somebody says $500 million. On the highest part, it is $2.8 million. We do not know how much it is. But the fact remains that out of 10,000 molecules, only one molecule hits. Today, the time is quite reduced. And as Sir has indicated, the patent life is only 20 years. Patent life from the time of filing the patent till the patent expires. But actual commercial life, as Sir has indicated, is not more than 4 to 5 years. But in that also, you can get a lot of therapeutic substitutes which could be better than the patented product. When you have got a therapeutic substitute to address to the therapeutic indication, why will you go for a patented product which is expensive? To cut the story short, our patent system is strong. To answer your question, which will not be the general question, we have Section 3D, we have got pre-grant opposition, we have got post-grant opposition, we have got voluntary licensing, and we have got compulsory licensing. So far, compulsory licensing has been used only for one product, that is for the kidney disease of Novartis, sorafenib. That's the only product. So our system is quite powerful, and there cannot be evergreening at all. That's first part. Second part, now we get, ultimately all these MNCs that you have seen in last 1 year, they are trying to withdraw because they don't have muscle power, or they try to, collaborate with Indian companies like Cipla, like, Dr. Reddy's lab, like Zydus Cadila, so that they can, go out. As Sir has indicated that, we have 68% people in rural India and 32% in urban India. Pharmaceutical cells or hospital cells come from 30%. 70% cells come from the 30%. Right? So there is an issue of penetration. Now, to address this issue, government has started, the Janaushadhi Yojana. Now we are trying to talk about generic and the trademark. Now the Janaushadhi Yojana, let me tell you that the understanding of generic and brand is not so clear, even with the regulators. I remember when I interacted with the CEO of Generic Aushadhi, Sachin Jain, who has been IRS, who worked with ICICI Bank before, even he was also not clear what is generic and what is traded. Anyway, we are not in the process of developing knowledge, as Sir has said that it may take 5 o'clock, by the time we finish. For our understanding, despite what Dr. Tilak has said very nicely, for our understanding, we have branded generic for general public, not for patented, not for oncology. It's altogether different ballgame. It's a small market, value market, not volume market. For us, it is branded generic, generic, and traded generic. All the media debate that you ask, that you see, that you read, is about the quality is related to traded generic, not branded generic and generic. For example, paracetamol. In India, he has already talked about India advantage. I echo his thought process. In addition, let me tell you, we have got 8.5 lakh chemists in the country. And chemist, major sale is not pharma, it's only 40 to 50%. In cities, chemist even sells, everything, including bread and including eggs. Right? So, major source, is not only pharmaceuticals. So we have 8.5 lakh chemists, we have 60,000 stockists, and we have got 10,000 carrying and forwarding agents. So we have got high fragmentation. And when you talk about brand, ultimately what is brand? Brand is a product plus. And that plus is in the mind of us. What is Jupiter Hospital in the mind of us? What is Compound in the mind of us? That consumer decides. And what is product? Philip Kotler defines product as anything that is offered to the market for attention, acquisition, use, or consumption is a product. That's a definition academically. Commercially speaking, strategically speaking, conceptually speaking, product is anything that has a value. And as Sir has indicated, price is a function of value. You want to come to Jupiter, you will get that type of a quality. Patient will get that type of service. The patient will get that type of satisfaction. So you come to Jupiter Hospital, you get that. If not, you go somewhere else. Coming back to the question that you asked about, MRPs. Somebody asked, MRPs are not same. Branded generic, I would not like to name. Some companies in India, they have got branded generic, they have generic, and they have also got traded generic, which is normally pushed in institutions like Command Hospital, CGHS, government hospital, railways, etc. Normally, they do not come to that. Whereas what is offered, as Sir has indicated, when Janaushadhi started, I remember Dr. Patankar, one of the secretary came to me that time. Our aim is to at least one store per district, and that time we had 628 districts. हमको खाली एक से हमको मदद करो. Now we have got 9,000 stores, and this is self-revenue generated. And let me tell you, whatever is available in the Janaushadhi Yojana generic or Prabodhan generic, they get only from WHO GMP compliant plants. So there's no question of quality at all from this. Please understand. Quality question can come in the generic, which is a traded generic, which is good. And as you know, somebody was asking, how do we look? Decision maker, when you go to generic, it is not in the hand of a professional doctor or healthcare professional. It goes to the trade. You write paracetamol, which paracetamol to push? Not naturally, chemist will push that paracetamol where his margins are high. So what you see is the MRP, which is being controlled. Paracetamol is a wrong name to take because paracetamol is an essential drug for which there is a cap. For a particular drug, there is a cap, which I'll try to talk in detail. So I thought of giving this, patented is altogether different one, right? So I answered both of your questions, right? Thank you for this.
Thank you, sir. So it is a trailer of his further talk. I'm sure we ready. Lunch at a different time. Now, moving ahead. See, we have enough time even during the lunch. You can definitely interact with the panelists and get your doubts clear. So the most important aspect in this particular field is the involvement of a physician, clinician, or the doctor who writes prescriptions. So what is his view? So that is quite important, and I actually request all of us to Dr. Walke sir to talk on the role of a healthcare professional in this particular area. I'm not going to specify, so you please be general in your comments.
When suddenly you are asked to go in and start batting, the only thing that I can do is just take one run and give the strike to somebody else. That's exactly what I want to do now. But I mean, all this that has been discussed today is something totally new for me. I mean, as a clinician, I don't know whether the clinician sitting here would have ever listened to that. And this is very good. I mean, this is what should be happening, because only when the pharmaceutical company and clinicians like Dr. Tilak and Sagar, when they interact with simple general clinicians like me, will come to know what's happening at the pharma level. For me, whenever I interact with pharma, it is all, I mean, to be very, this actually should be off the diet, but I get influenced by a pharma with the freebies that I get, with the conference ensure, I mean, that they sponsor me for conferences. And since I was the president of the Pune and Obstetric and Gynec Society, they sponsoring our events. So this is my interaction with the pharma, and this is how their drugs come into my field. So for clinicians, it is all about that. We have never been, I mean, open to such discussions here. So that's the way I look at a pharmaceutical company. And of course, I mean, when I write drugs, I come to know from my own clinical experience which drugs act better and which do not. But here, I think time has come for us to discuss and the ethical aspects of the freebies that are given by pharma. I mean, we cannot be just discussing this and trying to hide away those freebies that doctors are now suddenly find it very interesting to take.
Yes, please.
That's a very interesting thing that sir has brought out to the audience. For the information, there is something called a Sunshine Act in USA. Sunshine Act in USA is for the companies, the pharma companies, as well as, the stakeholders. All of them come out and disclose what all have they received and for what purpose they have received. So they are bound by the Sunshine Act every year to give a disclosure about the freebies and all these incentives that go into the stakeholders' pocket. In our country also, we've got a unified code for the same purpose, but that code doesn't have any regulatory teeth. It is a voluntary disclosure that all of us have to do, which we generally don't do. That's the unfortunate part. But this thing is also in pipeline. In days to come, people have to disclose what all freebies and what accountability from these companies that have come to them. So this is on the way.
So, I'm a part of a group known as Medic Logic, which deals all with this legal and ethical issues and all that. And very rightly, what Sir brought out, the question which comes to the mind is it ethical for a pharma company to sponsor my educational program? It is absolutely ethical to get books, sponsor clinical programs which are open, right? As regards freebies, there is a tight-lippedness in that. It's not actually ethical, but as regards educational programs and books or of such nature, educational material, it is absolutely ethical. Don't feel bad in.
If Sir permits, I'll just add to this because I have a very long experience handling these issues on ground. So please forgive me, and I will not be talking any theory. I'll tell you practically what we did, because when things start getting contentious, that is where a good administrator should step in, right? And the good administrator should not criticize, should not find fault, should not name or shame a doctor for accepting some small gift or something. It is silly, but should find a solution. जिसको बोलते हैं ना सांप भी मर जाए और लाठी भी नहीं टूटे. So what we did was we made the medical representatives very welcome in the both hospitals. I used to maintain those days cards लेकर के आते थे. I actually had folders. One folders for medicine, drug manufacturers and their distributors, and one for medical equipment. My medical equipment maintenance went up beautifully because I made the medical stores accessible to them. Develop a relationship. They are not your enemies. They need not be your chatty buddies, but they are not your enemies. They are your partners. Without their cooperation, without their wholehearted support, your medical equipment will lie idle. Your medical devices will not come on time. The patient will suffer. Your medicines will come with low shelf life. They will come with poor quality, right? So it is important for the administration as well to develop a relationship with the pharmaceutical companies. You raise the level. You ask the zonal managers to come and call on the medical stores or inventory in charge, whoever is the manager. The manager should deal with the manager. As far as medical reps was concerned, we made it a policy. And again, this policy cannot be made by a middle level manager. It has to come, as Sir will know, General Parmar Sir will know, it has to come from the commandant, CEO equivalent in the armed forces. So the policy was that if the medical rep comes to introduce a new drug, he or she is given a platform. We used to have monthly clinical meetings. Those clinical meetings ka chai pakoda they sponsor, apna board laga dete the. And after the clinical case and one administrative case was discussed, last May they were given 10-15 minutes to introduce their product. Win-win situation. Then what happens is, if the same drug is useful for 3 departments, the medical rep doesn't have to go to 3 departments. There is transparency. So what I'm trying to say is that there can be a way for ethical marketing also, which is beneficial both to the pharmaceutical industry as well as to the hospital. And none of the doctors will crib because it's an academic event. A little bit of gifts if somebody wants to give. I don't think we should go in there and start nitpicking. But in some cases, it reaches very unacceptable level. And ethics are individual. Ethics are a matter of individual choice. Very rare instances where ethics can be enforced. They have to come from within the clinician or even the administrator itself. Okay, so just that without elaborating on it. Ethical decisions jo lene hote hain, they are individual, but administrative decisions can be taken as an organization.
Thank you, madam. So it's a great sharing, and I'm sure you all will remember this. Of course, later on we are going to listen to madam when I will again request her for sharing her views. So we have a great person in the pharma industry, and he has now time till 4:55. So let me request him to share his thoughts on this particular interface. From his long experience, he's going to guide us, he's going to tell us the practicalities which we need to follow while pursuing this interface. So over to Mr. Vivek Padgaonkar. Want me to talk on pricing first, or you want me to talk on ethics and it? What? I think you should touch every topic. Okay, there's no problem. So can you just open my folder, please? Can somebody help? I think pricing is very important for us, and I will try to explain to you how the pricing is decided. I think all of us should be very happy, as Sir has indicated, that India advantage and India pharma advantage. We are reached to such a position that our contribution is huge in the world market. And as you said rightly, that the prices of pharmaceutical in India are lowest even in Bangladesh, Pakistan, and Sri Lanka. Even then we have issue, right? Even then we have issue. So let's try to understand how the pricing is done. I'm not trying to give big yarn, because I know that at the end of the day, you need to have a proper decision as how pricing decision has to be taken for yourself, for your organization, and how it is taken overall. Yeah, next please. Look, India is the only country where pharmaceutical or healthcare, right? Healthcare in general and pharmaceutical in specific is being controlled by 6 different ministries. Nowhere in the world, one industry is being governed by, regulated by 6 different ministries. Scroll down. Scroll down. Scroll down. Scroll down. Scroll down. Yeah. Now look, these are the 10 different acts which control healthcare industry. Right? So we are governed by the 10 different, there are many, but currently there are 10 acts, which are the key acts which try to govern our industry. Next. Yeah, I'll spend 5 minutes on this slide, and which will be meaningful for us to understand. This is in continuation with what Sir has said, right? Now, so far as the pricing is concerned, the industry is controlled by Ministry of Health and Family Welfare and Ministry of Chemicals and Fertilizers. Now, Ministry of Health and Family Welfare create something known as essential list of medicine, and this is being prepared by the experts in medicine and pharmacology, looking into the priority healthcare needs, disease pattern, cost effectiveness, and safety and efficacy. There are 6-7 criteria. These are the 4 criteria based on which essential list of medicine is being created. This has a root basically from WHO ELM, but each country has its own list. The effective national list of essential medicine has come only in 2011. So I don't want to talk about history. Currently, 2015 NLAB is in operation. It is mandatory as per DPCO 2013 that list has to be out in 5 years. So in 2020 September, National List of Essential Medicine has been announced but not notified. So today, both of us, industry is selling and you are utilizing the Essential List of Medicine from 2015. So this is on the part of Ministry of Health and Family Welfare. Now let's go to Ministry of Chemicals and Fertilizer. One of the important arms which governs your healthcare industry is Department of Pharmaceutical. And Department of Pharmaceutical, as Sir has indicated, has National Pharmaceutical Pricing Authority, which is an extension administrative arm looking after the pricing. Department of Pharmaceutical has designed National Pharmaceutical Pricing Policy 2012, which is in operation even today. And industry has a huge role to play into designing of this. Right? As Sir has indicated, there are 3 important principles of National Pharmaceutical Pricing Policy. One is essentiality of medicine. Second is a market-based pricing. And third, which is a paradigm shift from earlier policy, is the pricing of formulations only, not bulk drug or API. So with these principles, DPCO 2013 has been designed, which has 32 paragraphs. So DPCO 2013 is an implementation document for National Pharmaceutical Pricing Policy 2012, given in the hand of National Pharmaceutical Pricing Authority. So they sit with the lens. And every day there are a lot of cases which are going on. And that's why what you need to know, I will try to explain this to you so that you don't come into the forefront tomorrow. Unnecessarily get media exposure for no crime of yours. Right? So for our understanding, DPCO 2013 has got 2 sets of formulation. One is a scheduled formulation, another is a non-scheduled formulation. Now, what is scheduled formulation? Now, scheduled formulations are those which are included into Schedule 1 to DPCO 2030. Now, which are these formulations? These formulations have to be essentially taken from national list of essential medicine. Is it necessary that entire list has to be taken? DPCO does not say that. But practice is that when DPCO 2013 came into existence, in Schedule 1, all national list of essential medicine 2011 were included, which were 348 medicines, 670 formulations. Today, you have got 378 medicines, close to around 900 formulations for which ceiling price have been given. All those which do not fall into schedule formulation becomes non-schedule formulation. Right? I do not want to get into legality. A lot of maramari is going on between industry and government, and I'm helping a lot of my client companies to differentiate between schedule and non-schedule. But purpose of our understanding, what is not scheduled is non-scheduled. Right? Next, please. Topic which was given was pricing strategy. Then I said, Dr. Kashyap, that I will require full day about pricing strategy, because I will start, being a teacher at heart, I would not like to just operational announcement. When sir was talking something, my mind was indicating, the factors that drive prescription vary from category to category. So when I meet a gynecologist, category varies. When I meet orthopedician, category varies. So when I have to design my program, my offering should be such. Today in market there is a mess, because please understand, market is growing. Pharma industry is the only industry which is growing more than the GDP growth of the country, contributing last 8-9 years more to the GDP. And when the market is fragmented, every Tom, Dick and Harry gets benefit out of it. And today, we have got more than 5,000 companies. 185 companies have got 95% market share. So 5,000 minus 185 are the ones which are struggling for 5% market share. And what media talks is about only this 5%. Unfortunately. Anyway, so since the pricing strategy is important topic, objective, strategy, and tactic is fundamental. Principles don't change irrespective of your life, irrespective of your functional area. Objective is the destination that you want to reach, qualitative or quantitative. Strategy is a roadmap, and tactic is a vehicle that you use. Most of the time, people talk tactical, and that's a tragedy, not a strategy. You ask somebody, this is our strategy. I laugh, look, this is your tactic. And when you say this is your strategy, you are wasting your resources. This is what happened precisely in industry. And we are comfortable, doing labor. We are labor by mentality. Outside we go, we get less price, we do more work. In our own house, we don't want to work. We are outsiders coming here. Anyway, so objective, strategy, and tactic, right? So if you see how the prices are fixed, there are two dimensions: price fixation and price revision. As sir has indicated, that ceiling price is decided for the schedule formulation. So paracetamol, which you see in the limelight today, is being price controlled drug. Despite the fact that more than 20 manufacturers have written to NPPA that bulk drug prices of paracetamol have gone up 10 times more, still you are controlling the price, we cannot sell. And I'm surprised still paracetamol is available. That means companies are trying to make money in some other form. Definitely they're making loss in selling paracetamol. There's no doubt about it. The ceiling price which is offered by NPPA, no company can afford, including Glaxo, which is making crocin, to Geno, which is making Algina. Right? So that is about ceiling price, which is already covered. Right? Price revision. How the price revision? For non-scheduled formulation, you don't have to apply for price, it is your free price when you enter in. But there are certain areas, you buy product from a particular company, whether it is a new product, if it is a new product, you have to take approval from NPPA. Most of the companies get caught. Because today, definition of marketeer and definition of manufacturer is same as per DCGI guideline. So not that I and Dr. Kakadi decide to produce paracetamol and sell it to people. So we will be manufacturer, we will be marketeer from the regulator angle. So even if you market, we are responsible for the quality. Okay, so that is so far as the price fixation is concerned. Coming to price revision, how the price revision has to be done? After a period of a year, for the ceiling price, government gives the price based on the weighted production index of last 12 months, WPI. Right? As per WPI, this is announced. You are not expected to give your product more than that. If you do that, under para 20, you will get a license for overcharging. Many companies get their first licenses. Then For the non-scheduled formulation, you can increase your price only by 10% once in a year, not more than that. So that's what is the price revision. And as sir has indicated, price monitoring is being done by the price monitoring research units in different states. In addition, the trade audit also tries to see how the prices are moving in the market. So to make drug, as you said that 1997 NPPA was formed, their job is to make the drug available in the market. They will not allow anybody to discontinue just because your product is not commercially viable. So this is so far as the pricing is concerned. Next. I'll quickly talk about the capping and then I'll give it to next topic because we have got a laundry list of topics to cover. Now look, trade margin is the one which, today there is no law which decides price of the drug, MRP of the drug other than scheduled formulation for selling price. There is no law. But yes, trade margin is being defined in DPCO as a 16% margin. So selling price for 16% becomes your MRP. Unfortunately, what is happening in the marketplace, that AIOCD, All India Chemist and Druggist Organization, is very strong. They try to flex their muscle. In the process, industry gives 10% to the wholesaler and 20% to the retailer. That's a practice. So policy versus practice, right? And even both are responsible, industry as well as trade both. And ultimately, you and me as a consumer, we suffer because we pay more money. Now, the question is trade margin, is a trade margin between the trade and the company. And actually speaking, it is left to the trade. Kitna dena chahiye. Say, if you take a FMCG product, the margin is not more than 3 to 4% because they spend huge money on advertising, right? Whereas pharma company, as sir has indicated, that gifts, sample, literature, sponsorship, conferences, all are the elements of promotion mix. What is ethical is left to your heart. What is legal is left to your brain, right? So it is a question of mind over matter. If you don't mind, it doesn't matter, right? So ethics is ill-defined. Ethics are not clearly defined. There's no law defines ethics. Now, you say companies are giving money to the doctor. Companies say, look, I am making a profit. Doctor is a trader because he has to get a license today. Unfortunate part. We respect doctor in the high esteem because of the prolonged number of years of education, large number of hours, as he has indicated. He's like God for us. But then companies say, look, I am getting some profit. I am giving some profit to him. What's wrong? He's my partner in my business. So if you see ethically, it's not. And today I am not. I will talk about it slightly later. Uniform Code of Pharmaceutical Marketing Practices is a code which is self-regulatory. It is not statutory or it is not mandatory. Code is a code. Follow it or don't follow it. It is left to your conviction, right? So now coming to the trade margin. Now there is a capping of trade margin which is occurring. In fact, 6-7 months back, when Amitabh Kant was talking at one of the conferences during COVID time, he indicated that they are trying to experiment it out, utilizing para 19, which gives a plenary power, which gives the plenary power to DPCO that under extraordinary circumstances and in the public interest, NPPA can decide the price, change the price of any products or scheduled or non-scheduled formulation. That is being practiced today, and that has become the talk in the industry. If that is being done, the controlling will become maximum. Price control will be enhanced. Today, hardly 18 to 20% of the pharma industry. Today's size of the pharma industry is 1,85,000 crore, growing by more than 12%. Usme se khali 18 to 20% is only price control. Rest is free. And as somebody indicated that when the product comes under price control, what company does? Gets out of it, creates some FDC, and try to impress on the doctor as how my product is better than the single formulation, and doctor gets convinced and you get right prescription. Right? So this is a quick snapshot on the pricing strategy. Right? Over to you, sir.
Madam is saying there is no lunch today. So it's a good explanation by Mr. Padgaonkar. Since he comes from the industry, the aspects which he has discussed, they are definitely useful. Now coming to, since we have a time limitation, we will come to an end of this panel discussion. But then before that, let us now quickly recapitulate the
basic aspects which are useful as a hospital administrator. But of course, I am leaving it to Madam because she is the expert on this particular field. So I request Madam to give a take-home message of this panel discussion.
At the outset, I don't count myself as an expert. The only reason that I said yes to come here at absolutely 1 minute notice was because of the practical experience that I've had. And believe me, even things like issues in clinical trials, conflict of interest in research publications, I have seen these at very close quarters. You know, what happens is that when a pharmaceutical company is sponsoring a particular research, and I say it with a lot of responsibility because I read all top world-class journals, they all come into my Gmail. I have never stopped their subscription. If you go and see on Google search also, you'll see that while a trial is going on, even at that time, if a pharmaceutical company is sponsoring the particular research, some adverse events are suppressed. I won't say they are deleted. Their importance is suppressed. It's a very subtle thing, right? And they come out, those adverse events come out only when the drug is released into the market after the approval. Because then instead of 1,000 people in trial, millions of people start using the drug. So those side effects can no longer be hidden. And that results in recalls. So there has to be a legal and ethical parameter for clinical trials and research also. And that is why doctors who are involved in research, when new molecules are being, researched and they are being released into the market, even they have to have legal and ethical guidelines. The research is what published in journals like the Lancet. And after that, the drug has been recalled. And the company, I'm sorry, the company has waited quietly for the return on their investment. For 10 years, they knew that the drug is not beneficial the way it was claimed to be, right? But they waited for the return on investment and only then started recalling the drug, and there was no penalty. The only penalty levied was that the cost of the supplied product to the hospital was reimbursed to the purchaser. That's all. And they came and physically picked up the remaining product. This also I have seen. And this is a result of unethical research, unethical FDA approval, and post-marketing survey. Thank God the company was at least ethical about that. That at least they were tracking and monitoring what is happening after the drug is released into the market. So, ladies and gentlemen, the responsibility of healthcare professionals and pharmaceutical leaders cannot be underestimated. You are dealing with patients' lives here. And when there is a whole family going below poverty line, and the chief bread earner is committing suicide because he or she can neither afford the elderly father's bills, nor he wants to give sign-on DNR and take the father out and allow him to die, so he goes and commits suicide. Don't you think that it is criminal for us to be negligent in performing our legal and ethical duties as well? Because we have short sight. We are not long-sighted. We are not thinking ahead as to what our actions or omissions are going to result in. We close our eyes and say, kya farak padta hai if we don't tell this complication during the publication of the paper. At least they say that it was sponsored by XYZ. But the reality comes out after some time. And during that time, how many people have paid that money for a drug which was either not effective or worse, caused a side effect which was detected later? Where is the penalty? There is no penalty most of the time. Even as a country like America is struggling, the opioid crisis, they've had a out-of-court settlement. Kuch nahi kiya unhone. So this is a very, very sensitive, important issue. Price capping is and I always say that law has to come in only when ethics fail. If the healthcare professionals and the pharmaceutical leaders are careless or they don't care about ethics, code of ethics hoga, then somebody has to come to the rescue of the poor patient
Where is the patient in this discussion? So when the patient gets harmed financially, physically, medically, sometimes losing life due to suicide, then the government cracks the whip. It has cracked the whip on pharmaceutical industry with pricing strategy or price capping. And sooner or later, there are rumblings about stopping all the gifts and freebies being given by the. So my take on this is that if you follow ethics, the need for a very harsh law will probably go away. And if that doesn't happen, because we are who we are, then don't crib about the law. The law will step in if ethics don't. That is my conclusion in this particular discussion. Thank you.
So you all will agree that it was a very lively discussion, and every participant, rather every panelist, has given us the best information. And finally, it is concluded by Madam. And the take-home message is that this particular knowledge of interface is now a beginning in your mind. And as and when you come across during your work as a hospital administrator, you need to remember these messages. And with this, let me come to the end of this particular panel discussion. I thank every panelist for being part of this lively discussion. And at the end, let me thank Colonel Kashyap Madam for giving me this opportunity to be a moderator of this particular discussion. And let me thank all of you for patient listening. Thank you all.
I request the panelists to stay a little longer. And I request Dr. Vikas Patil, Medical Superintendent, Jupiter Hospitals, to felicitate the panelists for their eye-opening discussions. Yes.
Thank you so much.
Okay, okay.
Thank you very much. Thanks.
In case our dear,
Are we breaking for lunch, or
Sir.
the session will continue?
no sir, in case our dear audience,
Let me thank
Sir.
the CEO of this hospital, Dr. Rajendra Patanka, for providing opportunity to all of us. Thank you very much.
in case our dear audience is having difficulty in keeping their eyes open due to hypoglycemic effects, as ma'am just pointed out, of concentrating for too long, you'd be happy to know that lunch break will be in effect till 1500 hours. We shall reconvene then to start with the fourth talk of the seminar on end-of-life decisions in critical care. So the same location as for the tea, right across the corner. We'll be back here at 3 p.m. We'll be back here at 3 p.m. Thank you so much.
is there for Dr. Dilip.
More than halfway.
Change the line. Little longer, बहुत हो गया, कुछ और हो गया, ठीक है? I was requested to get still little longer.
Very exciting.
Oh, where? Because of the lights? अरे knowledge का थोड़ा सा अपन we should always update you. There is no point. See, TRIPS is trade-related intellectual property, in short IPR. So what I covered, so far as the India, what is your background? Why I'm asking you so that I should talk relevant. No? So if I talk in here.
No, sir, it was very good.
Oh, very nice. So I'll tell you, issue is that people talk about IPR. People talk about India patents are.
Actually,
patent infringement occurs.
actually, I didn't want to push that topic.
Because that was different. Because it was not. It's a very huge
Sir,
topic.
that light is coming on your face. I think so. We'll.
Because, it is very.
Patents Act and
So why don't you organize talk on Indian patent? It's a huge topic. For India, it's related to 4, as I told you. Section 3, evergreen, pre-grant opposition, post-grant opposition, and the compulsory licensing and voluntary compulsory license. So related to this, this has to be elaborated more.
So I think this is what actually touches me. Actually touches me. Then only I.
So where I should stand?
Yes, sir.
Don't keep gap, no?
नहीं तो फोटो में
क्यों काटना नहीं?
कहाँ काटेगी?
ये तो ट्रेलर है.
Thank you very much.
Sir, can I have your number, please?
Yeah.
I'll just write it. Pleasure knowing you, sir.
Yeah,
The entire
I'll
panel.
just give you number.
दो लोग actually थोड़े कट गए, so we'll take photo from you. We'll definitely have it on this thing.
Yes.
Yes,
Yes, I learned so many things from you
Yeah,
today.
yes. It was very fine,
Very
insightful.
This is my hospital today. Before that, I have served in 24 years in Indian Army.
Oh.
And then from 10,000 onwards, I was in the corporate sector.
Actually क्या मालूम कॉर्पोरेट का इशू अलग है
अलग है आदमी
रेट का अलग है आदमी का अलग है I never wanted to interfere because it will become patented is altogether different
you cannot
cannot change so the trade is different so everywhere the situations are different.
What I did in it, she also has got some obligations.
Yeah.
and giving the CVs and all this thing when it comes to the hospital, I just tell one thing: you can visit my consultants. Whatever discount you want to give it to my pharmacy so that I can pass it on to the patients.
Absolutely.
That is
Today, I tell you, some of the hospitals where I am consulting, they made huge profit in their pharmacy because of the normal. I said, you change this.
I can even today without closing my eyes, even if someone is taking them 500%, this kit will be 10 to 12%. Still there is a margin.
Yeah.
So this is what what they are talking about. Ethics should be from the heart, but for the greatest good of the good.
Look, we have to be in business, but at the same time,
Sir, we have
yeah, there is.
same.
Sure. It depends upon your person. Product management is a marketing. So what you are referring marketing is actually selling. So what selling? If you ask me wherever you want to go, your industry you want to go, you start with the sales. You must understand how the revenue is generated. Then you can enter into marketing. So marketing जो देख रहे हो, marketing नहीं है, selling है. What's your name? Yes, I am. Where are you studying? Is growing industry. Well. Okay, thank you.
But second phase was cancer is now. The promotion was due in March. They have sent it again. Actually, yes, that's what this
चार्जर लेके जाऊं थोड़ी देर
कर दो क्या मैं
नहीं होगी
How can you not have a reserve stock? एक नसीब stock है, पिछला साल हमको बोला what is the cycle?
कैसे हैं? अरे आज बहुत दिनों बाद वो एक इंची कोड दिखे यहाँ पे। हाँ कर सकते हैं। बीच में मिलेंगे अभी
इसकी बैटरी ये भी अपने को देखना पड़ेगा। उधर देखो क्या उधर सही है।
बच्चे भी बच्चे एक हैं अभी अलग ये हाँ तो कौन बात नहीं वो तो वन वर्ड बुधा है वो तो नकल वर्ड पे है मेरा ये और ये तो बॉटनिकल गार्डन ना यूएस बॉटनिकल गार्डन
टॉयलेट का काम नहीं करना है कुछ लीकेज टॉयलेट